Pardon, my lord. Pardon, my lord. 9 years custody, my lord. For praying for bail. Yes. 9 years custody, my lord. Praying for bail. Criminal appeal. The committed appellant is committed for the offence under section 376 and the PO and POCSO Act.
No, what is the sentence you have undergone?
Sentence 20 years. It is 2 years. 2 years.
2 years cannot be listed here.
It is
7 years above hele ethi apun padu nanti ye kon kara ji 2 years ethi list hi paribo. Yes.
Weekly list item 4. Mishap in the family mom. I can't tell 1 week after.
So we'll see that. We'll see that.
Okay.
Yes.
Supplemental list item number 1.
May I please, my lord? And petition has taken custody, my lord, since 12/12/2014. 12/12/2014, my lord. 9 years, 7 months in custody.
12/12/2014.
My lord.
Okay.
Convicted under section, my lord. But 302 to 394, 397, 201 by 34 IPC, my lord. RI for life for 302 and 394 with 10 years and RI for 3 months for 201 by 34 IPC. The appellant has been arrested while the informant was conducting a patrolling in another case. He apprehended the petitioner on 12/12/24. And while they were in police custody, the petitioner, the appellant, he confessed that he has committed the murder of the deceased and took away the motorcycle and one pen drive from the petitioner. And after the occurrence, they throw the dead body in the jungle. And thereafter, the case was instituted. During the course of trial, the witness.
The case based on circumstances.
Yes, there is no direct evidence in this case.
Yes. What are the circumstances?
First, confession before the police. Second, notice of recovery of the dead body of the deceased.
Where the dead body was recovered?
In the jungle. In the NH, it is the jungle. And third, the motorcycle and that pen drive was recovered from the petitioner.
Of the motorcycle of the deceased.
Yes,
and pen drive.
Pen drive of the deceased.
It was recovered from
this appellant.
Yes.
PW1 is the informant. 2, 3 are the witness to the 27 Evidence Act. And they have stated that while they were in police custody, he went to the jungle and the dead body is recovered from the spot itself. And another thing,
you are the only person who was facing trial.
Yes, my lord.
So, where is the material for which you have been found guilty with head of 34?
And others, my lord, they were also arrested, my lord. One is juvenile, my lord. And another, my lord, he is also convicted, but he has not referred any appeal, my lord. 3 persons were, my lord, convicted, my lord.
3 persons. No, this judgment.
It shows only one the appellant, my lord.
Yes, split of trial.
Okay.
No, initially the charge was framed against two.
Yes, against two.
Against two.
Uh-huh.
So while the trial was in proceeding, one absconded.
No, my lord. Absconded, but my lord, that co-accused, my lord. Till date also he's absconding, my lord. So I can find out.
Split up.
Split up, my
And
lord.
it is only against the present petitioner that the trial proceeded and he is convicted.
Yes, my lord.
What is your criminal antecedent?
No, there's no case pending against him.
Hmm?
There's no case pending against him.
That has not come in, sir. Not sought for.
Then you obtain instruction.
Apart from this case, there is no case pending.
All right, let him obtain
Yes,
it. IA number 921 of 23. This is an application for bail. Learned counsel for the state seeks some time to obtain instruction regarding the criminal antecedent, if any, against the petitioner. Put up this matter in the week commencing from 29th July 2024. You are not released on
No, my lord.
during
No, my lord. On date of arrest, I'm in custody, my lord. Since 12
maybe
to
that during that corona period you might have been. So you bring also the produce that custody certificates. Also produce the custody.
my lord.
Who
Sir.
did? Who did?
Assured us.
Yes.
So I fix up a date, my lord. That's right.
29th.
From this week. That's all. Result.
Item number 2.
Yes, Mr. Rao.
Lordships remembers, this is a case, my lord, where the petitioner was working as member board of revenue, and during his service, while working here, there was according to the department, that there were some judgments which were passed by him.
Some
Judgments
Acha.
which were passed by him were contrary to the interest of the state. And therefore a disciplinary proceeding was initiated against him. An inquiry was conducted. In the inquiry, the report was that the allegations were that he has backdated the orders, and he has, without any authority, has entertained the application, did not give proper treatment to both the parties, counsel. All these things were the allegations. The inquiry report was that there was no backdating. And the entire purpose of this case was that the Peshkar of this subsequent commissioner, at his instance only, such a case was initiated, whatever some malafides were there on their part. Then, after the inquiry report,
that means inquiry officer give you a clean sheet.
Excuse me, clean sheet. Then the matter, it was considered by the disciplinary authority. Yes. Disciplinary authority found that although inquiry authority said that there was no punishment should not be given, yet in view of certain observations in the inquiry report, he felt no, some punishment should be given, and he gave a notice. Disciplinary authority issued a notice, and I have given a reply. Thereafter, the punishment was inflicted on him by saying that he should be withholding the monthly pension at the rate of 5% for 10 years.
10 years.
10 years. That was the punishment inflicted. Against that, I had gone to the Central Administrative Tribunal, questioning that, because my main concern of the argument was, if as a quasi-judicial authority or a judicial authority, if I pass some orders, unless some malafides are imputed, it cannot be said that judgment may be wrong, but then it cannot be said that I have committed any misconduct.
What about backdating the judgment?
That was the inquiry officer found that there was no backdating. There was no backdating.
the disciplinary authority
He
must
did
have
not. He did not touch
differed
on
from
that.
that.
He did not touch on that point.
Okay.
But what the disciplinary authority said that in course of the inquiry report,
Okay.
and there are some observations. At one stage, the in the reply of this present petitioner, saying that in the law, according to law, the backward people are there, they should be supported, all those things. He found that that is not the job of the judicial officer or while a person acting as a quasi-judicial authority, but that's for the legislature to think over. These are high-sounding words which were not some proper for this petitioner to say. Those are the certain observations. Based on those observations, the disciplinary authority said that there are certain observations against the petitioner, but ultimately only because there was no backdating, giving a final report that he should not be given any punishment is not warranted. That's according to the disciplinary authority. So the allegations now roll round the facts that whether there any misconduct was there. The question is, if the petitioner has been found with any adverse remark saying that he has backdated or with some malified intention he passed some orders, certainly he is liable to be punished, but not otherwise, merely because judgment may be wrong. So, in course of hearing, your lordships found that there are 6 cases while he was dealing as a member board of revenue that were dealt with for this, and your lordships have directed those records to be called for. They were also called for, and I have examined them, and nothing there to say that it was backdated or any such thing. Okay. So this is all the case, my lord. I would take your lordships to.
Before that, I have one question, Mr. The Court of Revenue has taken up this matter on review, or it is a fresh case that he has taken?
It is like this, my lord. There are 5 cases. In one case, it's not a suo motu review. Although in the charge it is said that I have suo motu review. That was not a suo motu review. A revision review was filed.
So the
So that case goes. Then the other case where there was a clerical mistake. For 88, it was mentioned 80.
Right.
So that need to be corrected. That there can't be any record shows that is case number 80.
So what was the order passed earlier before the review is taken? What was the review for? What was the review?
That's what I'm saying. There are 5 cases where reviews were there. In one case, only clerical mistake. Therefore, it was corrected.
But
in one case,
88 or 90?
88, it was recorded as 80, and therefore it should be 88.
That's all.
That's all. That's the mistake. And in another case, what has happened? Remand should have been made to the Tahsildar. It was made to the revenue officer.
The wrong order we review.
No, I am not on that. What I am saying is every authority, every tribunal has got an inherent power to correct its own mistakes.
Only
correcting a mistake.
Only to the extent it is applicable under Order 47 Rule 1. Review.
Order 47 Rule 1 is review.
Yeah.
But what I am saying is an inherent power is in all tribunals and courts to correct their own mistakes.
Correct.
That's not under Order 47.
But there is a
151 on.
What can be brought in review? There is a parameter.
There is a parameter.
It cannot be
Yes.
a wrong order to be reviewed and a
Yes, quite correct. He cannot review his order. My submission to your lordships there will be, okay, he has passed a wrong order by reviewing it. Let us go to that extent. And then the remedy available to the other side is there to challenge that. It's not a disciplinary procedure. It may be a wrong order. It can't be a disciplinary proceeding will be initiated for that. I can understand there are so many cases, some wrong orders are passed, maybe knowingly, unknowingly, or anything. Unless mala fides are there, it can't be said that because the order is wrong, he should be punished. If that is the case, my lord, all the judges in the entire country will be punished for every day.
No, if you go little behind it, because
Yes.
the
Yes.
court has gone behind the order already passed, which is not
Not permissible. I'm going to the extent of submitting that it's a wrong
it
order.
is not a wrong order. It is an order beyond the purview of the authority.
Quite correct.
And that is how it is mollified. Reason being, an order has been passed directing the recording of the name of the petitioner where he has not acquired the property in accordance with law. The property in question, which has been recorded in the name of the petitioner in the order of review, is not either by way of a teletransfer, not by way of a grant, a lease, a gift. So, the very recording of the land in the name of the petitioner being a government land, nowhere at any point of time the land was in favor of the vendor. So that is how in the review the authority has directed to record the name, which was not there in the original order. So that is all.
Is it your lordships are referring
No,
to?
no, Mr. Rao,
Yes.
what you just pointed out, at least I was under impression that it was a clerical mistake. You said that the date was sometime wrong somewhere. Is it just like that order, or the total order has been changed by way of that review?
No, only that corrections.
But
No, there are 5 cases. My lord might be referring to another case.
Yes.
I said one case,
Hmm.
and another case review was not suo moto by me, but by the review petition was filed before.
Okay.
Whatever the decision I have taken.
Hmm.
So the very basis that I have suo moto reviewed is not correct. That is all right.
Okay.
My lord is referring
what
to.
you mean to say that suppose you passed an order, you have the power to review. One party filed an application for review. You exercised your power of
Yes.
review, and in that way you change the order to some extent. Question is that whether changing that order would amount to malafide. That is the thing.
The point. Point is whether malafides can be inferred and attributed to me.
Yes.
That is the point. My
Because
lord is putting that
order,
question.
second order or review order can be challenged in the higher forum. Okay.
In fact, some writ petitions were filed against those cases.
No.
And all those writ petitions were disposed of, and one of the writ petitions was also dismissed according to my knowledge then that my order was confirmed. That is
But
there.
if you do not have any power of review, but you have exercised it and changed the first order,
Yes.
then the matter is different. But you say that you have got the power of review, petition was filed for review, and you exercise the power and you
rightly or
differ
wrongly,
from
I
the
have
earlier order. So
now, as I understand, my lord, the point which I am to answer and I am confronted with is whether in such a case where a glaring error is there in passing an order, can malafides be attributed to me? There must be some other material.
Right. Suppose, let us say, for example, we are dealing with this criminal appeals, death reference. On the face of it, we found that some judgment has been
wrongly.
Okay. Let us say that inadmissible evidence has been taken into account and he has convicted a person. The question is maybe that on the whether it can be said to
Another
be a
angle of
malafidness
appreciation, this way
or
or that
it's
way.
a ignorance, some other thing can be taken. So that is the thing what you are driving out, if that is your case. So ultimately, what has happened in the before the Central Administrative Tribunal? What happened?
That my case was dismissed.
Dismissed.
Dismissed thereafter and before your lordships. In the
So if we go to the root of the matter, we want to know that suppose, I hope you cannot disagree with this, that a finding given by the inquiry officer may not be accepted by the disciplinary case. Is there at that stage, is there any law that in what a case the disciplinary authority should differ from the finding arrived at by the inquiry officer?
There, my lord, the disciplinary authority, I must concede that has the power because his inquiry report is
No,
only
is
a
there any
material.
guide? Is there any guideline, or he can at his discretion he can defer, even if let us say the inquiry officer's finding is absolutely perfect. Let us say on the face of it is given reasoning, and say disciplinary. No, I will just lie.
Because
Mention
I
I do not agree, and I'm deferring. So can it be done in that way, or he has to at least give some reasons?
Speaking order.
A speaking order has to be. That is the thing.
He has to give a
So-
speaking order, differing with those
Definitely.
inquiry findings, and then call for an
Here in this case, what has happened? While deferring
he
with
has
the
given some reasons.
some reasons.
Some
have been-
reasons.
Okay.
But those reasons are not, according to my humble submission, not akin to the main controversy in the matter. Some observations of the inquiry officer he has picked up and said that when you give these observations, where the question of giving a final conclusion that no punishment should be there. That is what, if your lordship want, I can just take your lordships to that portion
So,
of
other side is ready. Mr. Bokta,
Bhokta.
you are there. You are the only opposite party who is to be heard in this case.
No,
Or
no.
any
State is the answering opposite party. State is the main answering opposite party.
Who is there?
On the basis of recommendation of the state government, we have passed the order under Annexure 1. So that the proceeding was initiated by the state government.
No, you have passed the order just as a post office.
No, on the basis of the recommendation, even if the
So even
Yes,
if recommendation is there, you have a
yes.
you can't just say
No.
that because recommendation is there, we pass the order.
No, not.
So states also you are
Yes.
to be heard
Yes.
on behalf of the opposite
My
party.
lord.
Who is
I'm calling Mr. Das.
Mr. Das probably handling this. Call him. Yes, Mr. You can proceed. Just a minute.
Instead of repeating the charges and other things, I straight away go to the report of the inquiry officer. At page 63. Paragraph 2. There is only one charge against the DO framed. This is quoted from the charge sheet.
Yes.
Page 63. That's got it.
Yes.
Sri Jagar Singh IAS, here no so and so, while working as Land Reforms Commissioner, Board of Revenue Orissa, Cuttack during 98-99, passed illegal and irregular orders in favor of private parties in settlement revision petition number so and so, causing huge loss to the government. Thus, he has committed grave misconduct and gross irregularity by his failure to maintain absolute integrity in the above matter and thereby violated Rule 3.1 of AS Conduct Rules 1968. The key words and phrases in this charge are passed illegal and irregular orders, committed grave misconduct, committed gross irregularity by his failure to maintain the absolute integrity. Pausing a minute, I would submit that there is no charge of malafides. The preamble to the charge sheet states that the DO committed such misconduct and irregularities while disposing of settlement revision petition cases. The imputation to the charge adds that thereby the DO caused huge loss to the government. The imputation annexure 2 of the charge sheet refers to 6 cases. SRP number so on, so the 6 cases list is there. The memo of evidence is essentially a synopsis of orders passed in the order sheets of the referred cases with 2 distinct exceptions. Exception 1, in item number 9, 10, 16, 30 and 37, the memo of evidence is the written report of the Peshkar dated 3/12/99 stating that the DO had passed final orders after relinquishing the charge as LRC, having taken away the case records for this purpose. Exception 2 is that item number 42 stating that vigilance cell has seized the relevant records for the purpose of investigation. The exception 2 may not be very relevant, but exception 1, that is the main crunch of the matter, where they say that the records were taken away by the DO and he has passed order subsequently. That the DO has furnished a written statement on 12/5/2006 in defense of the articles of charges. Read with the defense statement furnished by the DO to the General Administration Department, he has made the following points. The state government has not challenged the decision in the cases referred to articles of charge in appropriate court, but has instead started a disciplinary case. He has produced a decision of apex court in the petition number so and so that wrong interpretation of law cannot be ground for misconduct, nor can such mistakes indicate a lack of integrity without any supporting evidence. His decision as a revisional court were taken into the context of the history of Fulbani, in which settlement operations had not been completed, and the Tahsildar Fulbani wrongly assessed Abadi lands, not community recorded lands, but as government lands. That as a revisional court, he had powers to correct the mistake of law passed by the predecessors. That there is no interpolation in the order sheet in SPP SRP 88/92, this case number so and so, stating that the standing counsel was present. He was present. There is no evidence to show that he handed over any case record after relinquishing the charge. That he has not specifically addressed the points raised by the standing counsel, as the points could not be corroborated by the standing counsel, and because he furnished similar arguments in this case, therefore similar orders were passed. All orders were passed in good faith, following the procedures usually followed in settlement. The entire charge hinges on the written statement of the Peshkar dated 3/12/99. This written statement refers to 35 cases, which the DO is reported to have taken with him after relinquishing the charge of the post of Land Reforms Commissioner on 14/10/99 and had written judgments on 25/11/99 with backdated signature. The conclusion that the disciplinary authority has drawn from this statement is that private parties have been favored by the passing orders when the DO ceased to be LRC. For the purpose of clarity, it is stated that DO relinquished the charge on 14/10/99. Reportedly, he took away the case records but returned the same on 25/11/99 with orders backdated to March 99. The ex-Peshkar, who has since retired, during examination by the MO on 22/2006, evaded confirming his written statement but added that he had given such a written statement because he was asked and pressurized to do so by the next LRC. Since the ex-Peshkar did not corroborate the written statement, the MO attempted to collect evidence by an examination of the court diary. On 18/4/2006, the court officer was asked about the maintenance of the case diary and shown that the diary has not been maintained between 8/6/99 to 24/8/99. But the ex-court officer pleaded his ignorance on the ground that the Peshkar is the custodian of the court diary and the case records, and he was not aware of the status of the postings. The court officer was examined relating to the procedure followed from the time a case is finally heard to the pronouncement of order. This procedure revealed no clue regarding the charge of backdating the orders. Interestingly, the MO was able to locate a second court diary maintained during the relevant period. This diary was better maintained than the earlier one, but it raised the question as to why there was a second diary. In addition, the second diary revealed that postings were not made faithfully and regularly. A statement prepared by the MO in regard to placed Annexure 6, unfortunately, the ex-Peshkar did not attend the final hearing on 1/5/2006 and could therefore not be asked as to why a second diary had been maintained and why postings had not been made regularly. The ex-Peshkar, in view of his denial of the truth of the written statement given by him, dated 3/12/99, and his absence on the final day, was taken to be an unreliable witness for the prosecution, in fact, a hostile witness. The undersigned, therefore, to form a view on the charge based on the limited unauthenticated information contained in the second court diary and 6 case records photocopies furnished by the annexers to the articles of charge, from the little information that was available in the second court diary and as seen in Annexure 4, Annexure 6, it was apparent that some postings were being made, and for instance, in case number SRP 101 by 92, there is a correlation between the postings in the CD and the orders passed by the DO in the case record. One can therefore believe that the postings were made as per the order sheets. Therefore, backdated orders, once having announced a date of judgment, would have been impossible. In dealing with this inquiry, not in the capacity of a member under the Board of Revenue Act, but as an inquiry officer so designated by government, I have restricted myself to an appreciation of the documents furnished in support of the charge sheet and the findings during the hearing. Only from the point of view of any possible irregularity with a common thread that could be considered to adversely reflect on the behavior of the delinquent as an officer. I cannot and did not go into the merits of the case cited in the charge sheet, but at the same time, I did not overlook acts of omission and commission that substantiate the charge. This I cannot do as I am not acting as a court. Accordingly, I have not thought it fit to dwell on the points raised by the DO in justifying his judgments in the referred cases. A perusal of the way of the delinquent officer has reported these 6 cases indeed.
Reopened. Yes.
6 cases indeed show a trend. The DO has routinely reopened cases decided by his predecessor without questioning why the petitioner, if aggrieved, had not gone to the appropriate court challenging the order. Long gaps between the order passed by the DO's predecessor and filing of these cases and review have not been questioned. Simple statements by the petitioner stating ignorance of law or absence from the headquarters have been accepted. On the other hand, review petitions filed by the government council have been summarily rejected, but more important, earlier decisions have been reopened. The superior courts have laid down general principle that same court cannot revise its own judgment passed on an earlier date unless there are mistakes of fact, clerical mistakes, or emergence of additional information that was not within the knowledge of the applicant when the earlier court was held. These mistakes have to be pointed out by the petitioners by the court, and only then the previous order be reopened. Conversely, in the absence of such instances, earlier judgments cannot be reversed. The pattern by which the DO has reopened earlier judgments is therefore questionable. They are questionable from the point of the conduct of the officer, but I am unable to come to any definite conclusion that these have implications on his integrity. The assertion in the written statement of defense dated 12/5/2006 that his predecessors have done such reviews earlier does not change the accepted principle stated. The DO, in emphasizing the history of settlement in Fulbani, has tried to give an impression that it was up to him as a revisional court to give historical justice. In my opinion, this is the task of the government. A court functioning under the OSS Act has to decide on the records available or order on the correction of records based on the related records and documents. As he himself has pointed out, no right or title can be given or extinguished under the OSS Act. Hence, reopening judgments in the garb of review and deciding the rights and title is not right given to him under law. While maintaining that the undersigned as an IO cannot comment on the decisions arrived at by the DO in his capacity as LRC, it could appear from the judgments that he has not given the weightage to the submissions made by the government council. His orders rejecting the objections filed by the government council are stereotyped and unsubstantiated. The DO says that review petitions cannot be filed under Section 7(1) of the Board of Revenue Act and Rule 43 of the OSS rules, but does not indicate why not. In fact, Rule 43 of OSS Act specifically provides for review under certain conditions. Section 7 is a wider power, but has to be read in the context of the Order 47 of CPC and pronouncement of the Supreme Court. No reason for rejecting the case in the case records the contention of the government council that review petitions filed by the petitioners were time barred, or that permission under Section 60 of COSMAL Regulations 1937 was from a competent authority was not taken or given. The same degree of scrutiny was not applied to the petitioner. When the earlier court had specifically stated that the petitioner has not provided supporting documents, including registered sale leaves. This issue has not been reiterated by the DO at the time of review. On the contrary, in the judgment dated 3/8/99, in SRP 110 of 92, there is a specific statement by the DO that the documents were seen earlier. The DO has denied this in his written statement. In conclusion, I am of the opinion that there is nothing on record to show that DO has made any backdated orders. The prosecution witness has also not stood by his written statement, but there is a strong impression that his orders have been biased in favor of private persons against the government counsel representing the government and therefore public interest. The Apex Court judgment of 1999, cited by the DO, while holding that a wrong interpretation of law cannot be a ground for misconduct, has also stated that, of course, it is a different matter altogether if it is deliberate and actuated by malafide. So, while a biased order against the government interest seemed to be apparent and that extent irregular, I am not in a position to assert that this speaks of lack of integrity or the DO himself is responsible for causing loss for the government. The DO has acted as a court, and any procedural irregularity ought to have been challenged before the next higher authority. I therefore cannot recommend any punishment to the delinquent officer. This inquiry report, as I said, that
You are exercising which power while this is it
recalling that
order 47 rule 1 or any other power?
the lordships may say that my submission will be order 47 will be applicable within the limited scope given there.
Yeah, that is what.
That's right. And 151 is there where mistake is there, one court can correct its own mistake. So my submission in the present case, after examining all those matters, I feel that as a tribunal or as an authority, quasi-judicial authority, he has exercised the powers vested in him to correct his own orders.
No, by reopening or by review?
But in a,
Yes, reopened or it is review?
If we place the two orders, let us say the first order, then the order which was reviewed, if these two orders will be. So the question is, you must have mentioned in that order that exercising this particular power of mine, I am passing this
correcting
order.
that, correcting.
So let us see those two orders, the first order and the second order. You are saying that no, it is not exactly comes under that order 47 rule 1. Then if that is not there, then which power? Is it 151 or so? And what kind of deviation, number one, was made from the other? This correction, this case numbers matter is totally different. But as has been pointed out, one order was totally changed, like
recording was made in favor of this. That from the explanation given by the delinquent, he says that that is an abadi land. That's not a government land at all. Taking it to be a government land, and if recording is done, definitely it can't be changed. But when the land nature of the land is different, the court records otherwise, then he has corrected it.
But then the earlier was a wrong order. It would have been otherwise
challenged. Right.
How it can be taken as a review? It could be a wrong order, as you said.
That's I understand. Well, I understand your lordship's point of view, but the question is, therefore, I am saying that even if it's a wrong order, what is next?
What is wrong? This one or the earlier?
Maybe either. Suppose now I am concerned to answer my orders only. Suppose I have passed a wrong order.
No, you have not passed a wrong order. You have passed an illegal order which is not vested in you. That is the whole thing. This power is
your lordships, with my great respect, I will submit that your lordships of the view, because of that patent illegal orders, it has to be presumed that there is a malafide.
No. reopening of the case under which provision, as my senior brother asked, under which provision he reopened. The self-same authority is reopening its own order and changing
predecessor orders also.
and changing it. How can it be? Can the judgment of this court be changed by this court, even if it is wrong?
Except this clerical.
Except this clerical or whatever
Any
is
any
applicable in
mistake, any
47.
it is like this, man. In one case, in one case, the matter was remanded, and that there was no compliance of that. Then he found that it should not have been remanded. There is no power to remand. So on verification,
Where is the scope for the authority to know about this? Is he reviewing all the case record every day? That it has
no,
come to his notice?
not that way, Millard. Once an order has been passed, as a follow-up, this compliance is not there, the case is not closed. When the compliance is not there, it might have come to his notice, or it might have placed
Yes, rightly, as
on
you
the
said. Suppose the compliance is not there and the matter is before him that this order has not been complied
right
by the Tahsildar.
Therefore, he noticed that the remand should have been to X and not Y.
No, but if detailed order has been passed, why it has been sent to the Tahsildar? A detailed order has been passed. Can that order be changed in so much?
But I'm going to the extent of saying, you're also right, Millard. I understand that. I'm going to the extent of saying that, yes, I have passed wrong orders.
Well, another thing about this date, the diary indicates that suppose the case was posted to a particular date, but by that, if that date is taken into account, you are no more there. So this, you took the file, passed the order, and it made it backdated to show that while you were
in office
or in the office, you passed the order. But in fact, this Pescar's diary indicates that it was.
But the inquiry officer's finding is that as per the order sheet, the diary dates are matching. The diary dates and as per the order sheet, but there are two diaries. Maybe that for noting purposes something is done. It often is done also in the civil courts that a small chitta is maintained where some notes are given, and finally orders of the main diary is maintained. So for ready reference, some notings might be there. It's not to make such a hue and cry that there are two diaries.
On one date and pass the order, or you heard the parties?
No. After the judgments, after the hearing is completed, postings are there. And as per the postings, the orders are there. There is no discrepancy there. What the inquiry officer found, that the order sheet notings and the diary are corroborating. Therefore, there is no question of any backdating. It is not a simple case that from the diary some dates were found and cases records were taken by him and passed wrong orders and brought all those things. But it is a case where the Peshkar says, who has given the report, saying that at the instance of the subsequent LRC, he had to make that complaint, wrong complaint. That malified is from the other side, not from my side. Rightly or wrongly, a complaint had come. So in these circumstances, well, the crux of the point, as your lordships are rightly pointing out, is whether even if a wrong order is there, whether it is a wrong order or not, if you deliberate, we have to go into the merits of the each case, and we have to see what should have been the order and what is the order and all those things. I don't think in a disciplinary proceeding we should go to that far to find out the correctness of the orders. Assuming that the orders are wrong, then what next? In all cases where the courts pass wrong orders, should be punished, or the courts will be punished or not. That cannot be the law, unless malifieds are there. As I have already pointed out to your lordships, that in the charge itself, there is a loss to the government, but not malifieds. At the instance of somebody I have done, that's not the case. I have taken bribe or done is not the case. No malifieds were imputed at all. in the charge sheet. What was said in the charge sheet is, because of these illegal and irregular orders, government was put to loss. Maybe one party is bound to be put to loss in a judgment. But can it be a charge? Can such a charge sustain against a disciplinary proceeding at all?
See, the question of malafide cannot be inferred directly from the
Records.
action of the party, except you go to the order. And that will only give you the inference as to the malafide. So it's the very case that the self-some authority, having found his predecessor to have passed some wrong order, to have been taken before the competent court of law. I, having succeeded to the office, found that my predecessor has passed some wrong order. If apparently on the face of the record to be reviewed for clerical mistake, number or anything, can be taken. Yes. As also you stated that under section 151, the court has inherent power to take up those things. But where I find that substantively an order has been passed by my predecessor to be a wrong one, so moto reopening the cases, changing the very substance of the reasoning passed by the predecessor, could be sustained, and can it not be inferred what is my intention behind it? If that I consider to be not only a wrong order, and I can reopen it by virtue of what? Is it by virtue of 151 or the provision supports my action? If the provision of law supports my action, then my action is correct. Or if at all not correct, can be taken in proper court of law. But if my action is not supported by law, what would be inferred?
That's right. There the question is, in a disciplinary proceeding, whether such an inference can be drawn.
Right.
If
inference from the order, action.
Action, right, right. Inference from the all the circumstances.
Also gone through in some part, but has ignored. He has also gone certain reopening of the earlier order and all that he has gone through.
Because
But
he was also an authority.
So,
but he says that as a inquiring officer, my limited purpose.
That is how it did not go in.
He did not go in.
But
so the only point that boils down for your lordship's consideration is whether in the circumstances when the order is glaringly a wrong one, an inference can be drawn for that there were malafides when the charge itself doesn't speak of malafides. No evidence is also there that there are malafides.
His law lexicon says malafide exercise of power. The definition, one of the definition is that it is so entirely divorced from or unconnected with the discharge of the duty that it was an independent act maliciously done or perpetrated. So that means what has been done in the second order, it was totally unconnected with your duty, or otherwise you could not have done it. You have no such power vested in law, but you did it. It was an independent act and done with a maliciously done, perpetrated. Then it can be said that one has exercised malafide exercise of power. So the very question again goes to the root that whether when you pass the second order, that means the review order, it is under what authority, which the power you are exercising when you change the order. If it is the clerical part is something different, but the very particular order which has been pointed out, it is totally changing the first one, right?
Totally changing. Yes.
So if whether that power was vested with you or not, that is the main thing. So if the power is vested with you, second order may be a wrong order.
Yes.
It
No.
cannot be said to be a malified one. But if you have got no power at all, but somehow rather you took it that and changed the order, the first one, then what can it be said?
I understand the question. But
That it is totally unconnected, not connected with your discharge of duty. I think you are harping that these are the two provision, that one is 151, the other one order 47 rule 1.
yes.
Is there any third provision?
Third provision means under the revenue law. Under the revenue laws, Orissa survey and settlement rules. There is a
let us
rule
see that
that is
review.
143. That is 41 and 40.
Yes.
43 is concept.
41 is one mistakes. And here, my lord, the case
and
record shows section 7.1 of the yes, my lord. Here the 7.1 of the case record is shows, my lord. I was going to the case record. There is the petition filed under section 15B for recalling of the order.
Yes. 15B was the application.
Yes, my lord. Orissa Survey Settlement.
No, Orissa
15B.
Survey and Settlement Act 1958. Mr. Rao, is there any provision which specifies that this is the power of review and it can be exercised under
Yes,
this
there are
state?
Section 7.1 of the Board of Revenue Act use the authority to the
Board of Revenue?
Board of
Yeah,
Revenue
yes,
Act.
sir. Okay, just okay. So let us write down that a Board of
Revenue Act.
Revenue Act section
7.
Section 7. It deals with review power.
Review.
Okay.
Power of the review for the member Board of Revenue to
Power of Board of Revenue on the extension of power.
This book why you saw this book, Orissa Survey and Settlement Act 1968.
41.
41. And this scope of the reading the and the petitions were filed under section Survey Settlement Act 15B, my lord.
41 says about the correction of
Exactly.
arithmetical mistake.
My lord. And the petitions which are filed, my lord, that is under section 15B. For recall of the order, my lord.
15B of
Survey Settlement Act.
Okay, let us see that. Read it up. That is revision by the Board of Revenue.
Yes.
The Board of Revenue may, in any case, direct fees on application made within 1 year from the date of final publication under section 12B, the revision of record of rights or any portion thereof, whether within the said period of 1 year or thereafter, but not so as to affect any order passed by civil court under section 42. So, provided no such direction.
Here the notice was there to the other side. I think it is so motto. There was no notice to the other side.
He writes that the government advocate was present in
all the review order. But is that those records you said that have you ଗୋଟେ record ଦେଲେ ସେ ଯୋଉ
There are some orders it mentioned that modification order. Some recall of
no,
order.
total records are 5 or 6.
That is 6 matter.
6.
6 matter. $88 deduction. 88 of this case 28/94 bolte. This miscellaneous petition has been filed by the petitioner for modification of the orders of the Honorable Land Reforms Commissioner in SRP 88/92 dated 25/11/93. The wrong reference of SRP 80/92 given in the petition does not relate to the case. Rather, the miscase relates to SRP 88/92. The contention of the counsel for the petitioner is that hall plot number so-and-so of Jingripada corresponds to Sabik plot number so-and-so. The Sabik recorded tenant against the suit plot is Vasudev Behra. The petitioner has purchased the land in question through an unregistered sale deed in the year 1951 and in peaceful possession. But during the current settlement operation, the land assistant settlement officer has erroneously recorded the land in the government Anabadi Khata 224 of Jingripada. The petitioner, having no other alternative, filed a revision petition, a revision under Section 15B of the Orissa Survey Settlement Act to get the suit land recorded in his favor. The Honorable Land Reforms Commissioner, after hearing SRP 82/92, remanded it to the Tahsildar Khandhamal with a direction to take appropriate action under Rule 34 of OSS rules if necessary. After verifying the documentary evidence in support of purchase and making field inquiry on possession. In this regard, it is prayed that the Honorable Commissioner has the direct jurisdictional power to entitlement. The unregistered sale deed has been filed for reference. Hence, the mispetition to allow the revision and order recording of the suit land in favor of the petitioner. The land standing counsel for the state is present on calls. He has also filed no counter argument in response to the claim. I find from the charge officer's report that the Sabik plot number so-and-so corresponds to hall plot number so-and-so. This plot was recorded in favor of the Vasudev Behra in Gharabari status during 1944 settlement, whose records were not finally published. However, the status rules of Khandhamal confers righty status on tenants recorded therein. The petitioner purchased the land in question through an unregistered sale deed for ₹80 on 19/2/51, which was not required to be registered from the recorded tenant Vasudev Behra. Subsequent sale, if any, by successors of Vasudev Behra is void. The encroachment cases have been started on the presumption that land is government land, whereas it is not so. The revision is therefore allowed.
Systematic
Allowed. Record hall plot number so-and-so in the name of petitioner and write the status in Gharabari case.
Order time
page 3 type put first page first page therefore at page 3 first page for a second reverse of the first page.
Therefore allowed.
Record hall plot number so-and-so.
This is the review order or the original order?
Review. That is the miscase filed. Miscase 28/94 filed by the petitioner and therefore reviewed.
So this no, it is not a suo moto.
No,
this is petition filed by the this petitioner means Abdul Azim filed the petitioner. State counsel was filed
and
present. And no counter argument was advanced. Then this order was passed.
Yes.
So,
and as per the section 7(1), 7 of Board of Revenue Accounts,
15B.
They filed that.
No, 15B has been filed earlier.
Yes, madam.
Basing on that,
Madam.
the authority directed the Tahsildar to look into the matter,
Madam.
and 15B was not subsequently filed. It is on the very same petition the court has gone. No separate 15B, because there cannot be two separate 15B. 15B has been
It in the question, the miscellaneous petition has been filed by petitioner.
as
Petitioner
if
means
before this, but it is not. As if before this court, but it was not before this court. It was filed earlier, basing on which the court had passed law. But here it shows as if it has been filed before.
My lord is taken which case number, my lord? Set for 88.
The first order was dated 25/11/93. In this,
Which was the first order?
first order is 25/11/93 in the first paragraph. The order which you placed, Mr. Rao,
Yes.
please see the decision that.
Because 88/92 was the application miscellaneous. So
This is the order dated 9th March 99.
What?
A order ta, jota mo place kori.
No, that is the review order.
Review order.
Review order is 9th March.
Right.
The first
Earlier
order
order was
is dated
25/11/93.
25/11/93.
93.
So after this 25/11/93 order was passed, in miscellaneous petition was filed.
Yes.
That petition was registered as miss case number 28 of 94.
Yes.
So obviously it was filed thereafter,
Yes.
and the court
Passed
passed this order dated 9th March 1999.
Correct.
And after hearing, the State Council did not file any counter argument, whatever it may be. So this miscellaneous petition has been filed under which provision of law? Have you got the copy of that petition? This petition which was filed and registered as miss case number 28 of 94. The copy, that petition is here.
No, the record. This one.
Entire report of
Second one of the board. In one case,
My lord, that is in 28, my lord, page 8, my lord. 8.
I don't know.
Page 8. That is by the state again. State has again filed another review petition. Or stated.
Settlement division decided so and so. The petitioner above named petitioner houchi state.
That is another petition.
No. It houchi miscellaneous petition filed by Abdul Azim. Tar petition da koda.
Top petition ta nahi hai. It is the state petition. Collector file. State file.
जो केसटा को जो पिटिशन को ये करिके नि रजिस्टर्ड हेछि मिस केस नंबर 28/94.
That petition is not there, but here this review petition has been filed by the state questioning this order. That page 8, they have questioned the order dated 9/3/99.
Case number on means of plural. This miscellaneous petition has been filed by the petitioner means same petition to base kari miss case number. Originality is arising out of miss case number 28/94 that provision only filed. Where is that petition? Mr. दास आपण से जो ऑर्डर टा मिस्टर राव बर्तमान प्रेस करथिले तार फर्स्ट पैराग्राफ को आसन बर्तमान जस्ट जोटा प्रेस करथिले
Madam.
ଆପଣ
Miss case 28, madam.
ହଁ ମିସ୍ କେସ୍ ନମ୍ବର 28 of first ଦେଖନ୍ତୁ this miscellaneous petition
Has been
has been filed by the petitioner. Petitioner କିଏ? Abdul Azim.
Abdul
ଠିକ ତ clear?
Madam.
For modification of the order of the Honorable Land Reform LRC in so and so dated 25/11/93
Madam.
ହେଲା so 25/11/93 ରେ ଗୋଟେ ଅର୍ଡର ପାସ୍ ହେଲା
ଆଜ୍ଞା।
ହେଲା
ଆଜ୍ଞା।
ତାକୁ ମଡିଫାଏ କରିବା ପାଇଁ ଗୋଟେ ମିସେଲାନିୟସ୍ ପିଟିସନ ଫାଇଲ ହେଇଛି
ଆଜ୍ଞା।
ସେଇ ମିସେଲାନିୟସ୍ ପିଟିସନ ଟା ରେଜିଷ୍ଟର୍ଡ ହେଇଛି ମିସ୍ କେସ୍ ନମ୍ବର 28 ଅଫ ଫ୍ଲୋରାଲ ଉପରେ ନମ୍ବର ଅଛି
ଆଜ୍ଞା।
ଏବଂ ସେଇଥିପାଇଁ ବ୍ରାକେଟ ଲେଖା ହେଇଛି arising out of settlement revision number 88 of 9 so we want to know जो मिसलानियस पिटिशन टा अब्दुल अजीम फाइल
then collector is not finding.
ଏଇଟା ଆଉ ଗୋଟେ ପଏଣ୍ଟ ଆସୁଛି if the collector has challenged this order then the question of disciplinary proceeding challenge must have been allowed or rejected.
So disciplinary proceeding is an independent proceeding and side by side the judicial order can
simultaneously it can proceed always but the question is
if that is so why this that cannot
you are producing the entire record then that petition should have been there here এটা ଆପଣ entire record ପୁରା produce କରୁଛନ୍ତି ଆଉ ସେଇଟା କୁଆଡେ ଗଲା
all government papers
ଦେଖିଲେ ସେଇ ଜିନିଷଟା ଏଇଟା ପରେ ଏଇ ଯୋଉଟା ତାପରେ
Autistic, they have also filed the written note of argument. State has filed. All the copies of state are available, but so far they are all subsequent after this order. No. Until the file is petition. Until the file is. Okay. Eight file settlement of the 173. 9 to 93. 110. Oh, 73 plus na.
ନାଇଁ ଏଇଟା 28 ଟା
173 କଣ ମିସ୍କେଟ 173
ପ୍ରଥମ ଯୋଉଟା
Find out that.
If you are producing the entire records of all the 6 cases, then why this petition is missing from? Because the what is Mr. Rao is pointing out, let us say that after that this particular order 25/11/1993 order was passed by the LRC, right? ये जो प्रथम पैराग्राफ को हमें कहूँ गोटे ऑर्डर 25/11/93 पास हला LRC पास कले देन पक्ष जी पिटिशनर अब्दुल अजीम से पैराग्राफ देखो जी he filed a petition for modification of that order dated 25/11/93 ताकू बेस करिकिन आपण रजिस्टर्ड करूचंती मिस केस नंबर 28 of 94 हला एवं सेही मिस केस नंबर 28 of 94 रो हियरिंग होउची हियरिंग हेले ऑर्डर शीट गोटे मेंटेन होउथिबो से ऑर्डर शीट काहे एवं ऑर्डर शीट मेंटेन हेगिनी एई ऑर्डर देखौची जे स्टैंडिंग काउंसिल किछि ता देरे काउंटर आर्गुमेंट देइनांती किछि कहनांती देन दिस ऑर्डर हैज बीन पास so let us say it's a wrong order the order should not have been this it has been passed question again is whether it is malified one or not. It is not a so moto exercise. Somebody has filed a petition, one of the party filed a petition, he in presence of the state matter was heard. Suppose that would be reflected from the order sheet of that miss case जे एमती गोटे पिटिशन फाइल कला गोटे रजिस्टर्ड हला ताकू डेट मध्ये जाइथिबो हला तेणु देखंतु आपण 94 मसिया रे पिटिशन टी फाइल हला ऑर्डर केबे हिची 99 मसिया रे तो 5 वर्ष धरि किनी ऑर्डर शीट मेंटेन हेतिबो से ऑर्डर शीट कोन मेंटेन हिची कोन देखौची से ऑर्डर शीट ता रेकॉर्ड काई and who is that officer who passed the first order that 25/11/93 order टा किए पास करथिले सेटा भी order pass modification petitioner has passed this 9th March 1999 order. It's all right, but who has passed that first order 25/11/93 25/11 order.
So you confined only to those documents which is the basis of the charge. That the earlier order was passed by LRC, a subsequent petition for modification was there, then this order or review petition is there. And which are the cases which is reopened and which is on the basis of application.
Because only we got the original order passed. What? Yes,
what is called for.
My lord. All the 6 cases which were referred on basis of some petition.
No, that is there. We find the other cases except 82, 88 of 92 that. Now
28, my lord.
The miss case 20. '28 of 94.
Good evening.
That's what record has to come.
Yes, madam.
So the order shows that there is an application, based on which the court has.
Exactly, madam.
Are you disputing this, that there is an application?
Yes, yes, sir.
So 93 is the order passed and 94 the application was filed.
Madam.
It was registered as miscase number or TC of CORAM.
Even the letter also shows that miscase 28 is there.
Exactly.
It's 1, 2, 3, 4, fifth page also there.
First
what-
page.
Yes.
Refer to that. So even if you come forward with the objection, you need to have those documents. Without that, how can
Yes, sir.
you get those documents?
Yes, madam.
Or Mr. It's wrong and senior at Mr. Uh, Das, government at Mr. Ranjan Gupta, Learning Council, CGC, no?
Right.
CGC. During course of argument on perusal of the decision rendered by the petitioner Jagar Singh in miscase number 28 of 94 on dated 9th March 1999, we found that one order was passed by the Land Reforms Commissioner in SRB number 88 of 92 on dated 25th November 1993. And then Abdul Aziz, Aziz na Azim, no? Azim, acha. Abdul Azim, the petitioner, in that miscase number 28 of 1994, filed a miscellaneous petition for modification of the aforesaid order dated 25/11/1993. Basing on his miscellaneous petition, miscase number 28 of 1994 was registered and ultimately the order dated 9th March 1999 was passed by the petitioner of this writ petition. The records which was produced by the London Council for the State doesn't contain the miscellaneous petition filed by Abdul Azim, basing on which miscase number 28 of 1994 was registered. Not it contains the entire order sheet of the miscase number 28 of 1994. When we make a made a query to the Learning Council for the state that where are those petition and the order sheet. He seeks some time to produce the entire, the original case record you produce. Okay, the original case record. He would take it up for this. So original case records of this miscase, this settlement revision number 88 of 92. So also miscase number 28 of 1994 with the order sheet. Clear? Pre-copy of the order be handed over to the Learning Council for the state. We are giving you 1 week time, so it can be taken off.
2 weeks time, Malad.
Then it will go to August then.
Malad.
We are keeping on a Tuesday so that it can be taken. So let it be on 6th August. List this matter on 6th August 2020.
Either 7th or
7th you want. All right. 7th August 2020. The order of first paragraph of the document will have taken it on. Yeah. Yes, sir. Yeah. Yes.
Brutus is Brutus.
That's the first one.
Weekly list passover item number 9.
Yes, what did you?
Yesterday, asked me to.
Oh, that man is alive or dead?
Yes, he's dead.
Dead.
From 2005, he died in the
That's all right. So he was just a minute. T02 and sentence is imprisonment for life. So 394 says that every other appeal under this chapter, except an appeal from a sentence of fine, shall finally abate on the death of the appellant, right? And of course, their near relatives can continue the appeal, but such a situation doesn't arise here. Nobody has filed within that prescribed period of that. केबे मला 2015
2005.
5 है वो. Yeah. Thank you. That's all. The petitioner, the appellant, has preferred this item
9.
CRA 81 of 1998, challenging the input judgment and order dated 19th January 1998, passed by the Learned Session Judge Dhenkanal Hon'Ble, Dhenkanal, in Sessions Trial number 46D of 1996, in which he was found guilty under section 302 of the IPC and sentenced to undergo imprisonment for life. As per the order dated 1/7/2024, the Lieutenant Counsel for the state has obtained instruction from IIC Bhuban Police Station dated 15/7/2024 to the effect that the appellant Raja Raya na Raja Raja alias Robby Naik Raja na Raya ये लिखा है जी Raya Raya alias Robby Naik died in the year 2005. The written instruction received is taken on record. Section 394 bracket 2 CRPC indicates that the appeal, except the appeal from a sentence of fine, shall finally abate on the death of the appellant. The provide to subsection 2 of section 394 empowers the appellate court to grant leave to continue the appeal in case any near relatives files an application within 30 days of the death of the appellant to continue the appeal. And in that case, the appeal shall not abate. In the case in hand, no such application being filed, the appeal stands greatly according to CRK.
Item number 15.
May plus. Criminal antecedent of the petitioner was confirmed.
Yes, sir. CR 457 of 2017. Gauri Naik. Yeah. Yes, this is found. So you are in custody since when?
Since when custody 25/1/2014. During Corona, he was released on bail and the custody certificate was produced like
As per the custody certificate,
8 years.
how many years you are in custody? Where is that custody certificate? You have got that custody certificate?
Yes, that was produced at the last. Eight years.
Yeah. केबे करेगा डेट के 7 years 6 हाँ 6/7/24 में रिसेंट 7 years 6 days 8 ବର୍ଷ 8 ମାସ 27 ଦିନ ପେରୋଲ ରେ ଯାଇଛି
ବର୍ଷେ
ନାଇଁ ନାଇଁ ତାକୁ ଏକ୍ସକ୍ଲୁଡ କରନା ଦିଆ
exclude କରିକି 7 years 3 days
ଆଉ ଏଇଟା କଣ 8 years ଲେ convicted details ଲେଖିଲେ ଆପଣ 8 years 8 months 27 ଦିନ
8 years.
ଆଗରୁ ଦେଖିଛି sir
no finally ଆପଣ
finally 8 years
ମିଶେଇକି ହଁ 8 years that you said 8 years 8 months okay so
Now
earlier your bail application has never been rejected by
not
this
rejected.
So you have been found guilty under section
302 by 34 of the IPC.
Okay. Yeah.
Sentenced to arrive for life.
So there is only one appellant here.
Here, madam.
So how many persons face trial? One.
One.
But you said
But
34 is there.
subsequently, other 2 persons arrested. They are in custody, madam.
Okay. So 302 by 34, life imprisonment.
Yes.
What is the prosecution case?
Prosecution case is made on. Now the appellant is aged about 70 years. The prosecution
70.
69, madam. 69 years some.
Okay.
The case of the prosecution is that there's someone has urinated near the cattle peg. It was found by the appellant. He, my lord, were abused, my lord, without naming any person. And on the next day, the appellant informed to his 2 sons. They came and again quarrel was ensued, and the allegation that the present appellant, gave an X blow.
Deceased. What is the name of the deceased?
This is the Trilochan Naik.
Trilochan Naik.
Yes, madam.
And date of occurrence is?
Date of occurrence is 22/12/2013.
22/12/2013. Yes, you dealt an X blow.
X blow.
On which part of the body?
To the head.
Okay.
And subsequently, the another son gave a blow by means of a bill hook. It is the case of the prosecution. For the doctor who is examined as PW7 and conducted autopsy, he found only one injury on the head of the deceased. And the eyewitnesses are, my lord, the PW2, 4 and 1. PW2 has narrated everything.
PW1, 2 and 4. Eyewitnesses.
Yes, madam.
PW2 has narrated from the beginning.
Yes, madam.
Let us see that. PW2.
I know the UTP Bauri Naik, who is from our village. I know the deceased Trilochan Naik. I know the informant Kumar Naik. This incident took place almost 3 years back. On the 11th day at about 7 a.m., Bauri Naik was tethering his cow. Someone had urinated on the cattle page. Bauri started to abuse without naming anyone. Trilochan protested, saying not to abuse entire villagers for that matter. Some altercation of words took place in between Bauri and Trilochan. I intervened and separated both the parties. Each of them went to their respective houses. Bauri informed his sons over phone. His sons, namely Sushanto and Dhuba, arrived in our village on that night. Next day, at about 7 a.m., Bauri, Sushant and Dhuba went in front of house of Trilochan. They challenged Trilochan to come out. Trilochan was standing near village tube. That village tube was within a close vicinity of the house of Trilochan. Sushant caught Trilochan from his backside. Bauri went and hit Trilochan with an axe, aiming his head. Dhuba went and also hit to Trilochan at his head. Trilochan fell down on the ground. After the incident,
That means 2 persons assaulted on the head.
yes, madam.
One you assaulted and the other is that Dhuba.
Dhuba, madam.
Dhuba is your son.
Yes, madam.
Yes, then what happened?
Then, madam, each of the accused person took away the respective weapons of offense with them while they were leaving the spot.
So what is the PM report?
PM report exhibit 5 and the doctor is, my lord, examined as PW7.
Fracture of skull.
Brain matter.
Brain matter only.
With brain matter exposed and blood stain. Fracture of skull.
So your submission is that 2 blows have been given
Yes.
as per the eyewitness
Yes.
account.
1, 2 and 4 all are stated that the
What happened to that Dhuba?
Dhuba, my lord, not arrested till date. He is absconding. That Sushanta
But
is
he has been charge sheeted.
and the Sushanta is in custody.
And about your age, you said that it is 69 or 70
Yes, my lord,
from
that
which month?
appeal, my lord, filed in the year 2017 and the age was
No, in the judgment, what is the age mentioned?
in the judgment, the age was 60 to
Quebec.
14.
2017. 68. Accused statement also you have stated your age. Accused statement.
Accused sir, copy not.
Yeah, yes. ବାରମ୍ବାର କହୁଛି ଗୋଟେ ହେଡିଂ କରିବ accused statement ବୋଲି। ହଁ 60 ହେଇଛି ସେ registered 2017, so it is 67,800. So during course of quarrel, single blow given by you, another blow given by that your son Toba.
Okay.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is aged about 70 years and he is in judicial custody. He was taken into judicial custody on 25/1/2024 and the custody certificate dated
2014.
dated 6/7/2024 indicates that the period is custody period is 8 years, 8 months and 27 days. It is submitted by the learned counsel for the petitioner that the occurrence in question took place on 22/12/2013. And though it is the prosecution case as per the eyewitness account of PWs 1, 2, and 4, that the petitioner, that during quarrel between the petitioner and the deceased Trilochon Naik, the petitioner assaulted the deceased on his head with an axe while his son Kontana Jidharthala
Thoba.
Sushant
Susan Dhorita.
Susanto caught hold of the deceased and another son Toba also assaulted on the head of the deceased, but the doctor bracket PW7 who conducted post-mortem examination has noticed only one deep sharp cutting injury over the right parietal area and opined the cause of death was due to brain hemorrhage. The learned counsel further submits that the Sushant is in judicial custody, whereas Dhoba, who according to the prosecution case assaulted on the head of the deceased, is still absconding. And since there is no chance of early hearing of the appeal in the near future and paper book has not been prepared, the bail application of the petitioner may be favorably considered. As per the order dated um, mm, so the learned counsel for the state has produced the written instruction received from the IIC Odagam police station dated 14/7/2024, which indicates that there is no criminal antecedent against the petitioner. The said report is taken on record. Considering the submission made by the learned counsel for the respective parties, the age of the petitioner, the surrounding circumstances under which the crime has been committed, and the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, so also absence of any criminal antecedent, we are inclined to release the petitioner on bail allowed.
Item number 17.
May I please also?
Yes.
Here the appellant is convicted on section 302 and 323 of the IPC law.
Just a minute. Single appellant?
Single appellant.
Paru alias Orun. Any order was passed previously, 9/7/24. Okay, so on to name of the Acha not required. Okay. By the way, what is the date of custody?
Date of custody 22/12/2012. About 11 years, 7 months as of date.
22/12. And you have been found guilty under section
302 and 323 of IPC law.
302 and 323. So, what is the name of the deceased?
Deceased, my lord, Narayan Dehuri.
Date of occurrence?
Date of occurrence 21/12/2012.
Eyewitnesses are there.
No, one witness is there, my lord. That
323 वाला माने eyewitness ही थी वो से ना?
his occurrence witness. When he was assaulted by the appellant, he ran to the village and called some villagers. While the villagers come to the spot, he found that he was assaulting another man. That he was lying. He was lying. On being asked to that person, he is told that the appellant has assaulted him.
No.
So he is the occurrence witness.
Is that man was assaulted and PW?
16.
PW 16. And who is the doctor?
PW 19, my lord.
19 is the doctor. So let us go to the doctor's evidence. How many blows you have given? And by what weapon?
Weapon, my lord, that kotta, that pole which is used for ahula maria po jo bounce use karanti, that kato maria pai.
Acha, kato se
that.
Okay. Multiple abrasion over the so bone, right knee, right ankle joint, left so left, okay. Middle arm. Acha. Multiple bruises, so okay. Then swelling of the lower arm. Fracture of 4th, 5th ribs. Okay. Fracture of 7th, 8th ribs, mid axillary line. Fracture of 3rd and 4th. Fracture of so. All the above injuries or antemortem might have been caused by time of the death. Cause of death due to hemorrhagic shock following injury to the vital organ like liver. Achha. So, and let us go to then PW 16.
16, madam.
Cordelate?
I know accused Borualis Barun Baghar standing in the dock. I know informant Sumanta Dehuri, and this is Narayan Dehuri, father of the informant. I am the injured in this case. The occurrence took place 3 years back at about 7 p.m. I was present at Barpadar Ghat. Accused Barun Baghar called me from other side and of the river, that from Gumur Singha Ghat. I reached Gumur Singha Ghat 10 minutes late. The accused abused me as to why I arrived late. I took him to Barpadar Ghat in my boat. After reaching there, accused has beaten me by means of an oar. The deceased Narayan Dehuri was present there, who protested. The accused thereafter assaulted Narayan Dehuri by means of said oar. The deceased fell down on the ground. I rushed to the village to call the villagers. Thereafter, I, along with Ananta, Sumanta, and Bulu, came to the spot. All being asked to Narayan Dehuri, he told that accused has assaulted by means of oar. Narayan Deori requested us to take him hospital soon. We took him to Kishore hospital. Doctor declared him dead in the hospital. I was medical examined in this case. I was examined by police in this case on the next morning of the occurrence. In the cross-examination, my lord, the defense that my village Basudevpur is 30 kilometers away from Barpada. I had been to village Barpada to call the villagers, which is 1 kilometer away
No,
from.
don't place those things. But you have assaulted with that or of course, it appears that that head has been spared, but other things, this chest portion, main assault is there, and so many ribs have been fractured, and one of the ribs might have caused injury to the liver. That is perhaps the cause of death, according to the doctors. So you are in custody for, you said that it is
In
about
fact,
11.
there is no motive at all. They were also known to, nobody is known to anybody that the person, they are not also known to each other. Out of anger, making assaulted.
ସେ କହିଲା ଯେ ଡଙ୍ଗା ନେଇକିନି ଏପଟକୁ ଆସିବାକୁ ଏଇଆ ତ
ଆଜ୍ଞା
ତ ଆପଣ ଟିକେ ବିଳମ୍ବରେ ପହଞ୍ଚେଇଲେ I reached अच्छा then accused abused me अच्छा PW 16 नहीं पहुंचेला
60
accused तक abuse कला then ये intervene कला okay accused thereafter assaulted us. So the deceased was a peaceful intervener and you assaulted him by means of that war, fell down and ଆଉ କଣ criminal antecedent କଣ ଅଛି?
But not there much. The other villagers who reached that spot, they also had from the deceased.
No, ଏଇ ଜିନିଷ ତ କହିଥିବେ ହବ ଆହୁଲାରେ ଡଙ୍ଗା ଆହୁଲାରେ ବାଡେଇଛି ଆଉ
hospital.
ହଁ. So this detention period is, as he said, it is 11 years and odd. So you have to just obtain that. Let us see that any criminal antecedent is there or not. That's a criminal. Can it be obtained on 29th? We are keeping it. 29th. The learned counsel for the petitioner submits that custody certificate produce କରିଛନ୍ତି?
No, sir, I have not.
ନାଇଁ ଆଚ୍ଛା produce
He's also never gone interim. He's in custody since then.
no ସେ period ଟାରେ ବହୁତ ଛଡା ହେଇଥିଲା ସେ ଯୋଉ COVID period ରେ submit that the petition is in judicial custody since and as such he has undergone substantive sentence of more than 11 years and 6 months. The learned counsel for the state takes some time to produce the custody certificate, so also to obtain instruction about the jail and also obtain instruction about the criminal antecedent if any against the appellant. Put up this matter on 29th July 20. Here.
Item number 21. Item number 22.
Yes. Huh? Oh, it's a weekly list. Yes, Mr. Japula.
Appellant has been convicted.
What order you passed in last date? Acha. Deposition copies were supplied to both of you. Okay. So item 22 CRLA 210 of 2019. Madan Sutta. So what is the date of custody?
Date of custody
10/4/2017.
10/4/2017. Right. and you have been not even released on interim bail by this court.
Right. This is my first bail application.
Okay. So, what is the name of the deceased here? 302, na?
302 by 201.
Okay. Name of the deceased?
Jasmine Sutar.
Jasmine
Sutar.
lady?
ছোট ঝিওটা।
ঝিওটা। You are related to that baby?
তার দাদা লেখা হব।
ସାନ ଭାଇର ନାତୁଣୀ ଗ୍ରାଣ୍ଡଡଟର ହବ ସାନ
ଗ୍ରାଣ୍ଡଡଟର ହବ ସାନ ଭାଇ।
ମଦନ ସୁତାର ହେଲା ଆପେଲାଣ୍ଟର ସାନ ଭାଇର ନାତୁଣୀ। There is no allegation of 376.
No, সেটা না।
What is the date of occurrence?
Date of occurrence is
3/4/2007.
That day that girl was missing.
Okay.
Thereafter they search for that girl, and they given a missing report on 5/4/2007. 5/4/2007. And subsequently dead body was found on 7/4/2007. That was floating in the pond.
Floating
in the pond.
Pond. Village pond. 10th ray.
7th.
That day FIR was lost.
In the FIR, the name of the petitioner is there?
Yes.
Suspect.
PW1 is the son of the petitioner Miller. He has disclosed it.
There is no eyewitness.
No
eyewitness. So, what are the circumstances the prosecution relies upon?
The PW1 has disclosed.
PW1 ki?
The son of the appellant.
Son of the appellant. What he has stated, let us
My lord. He is the main witness, and other have stated that on hearing from PW1 we came to know.
No, let us see. Face the PW1.
I know the informant. Accused is my father. Occurrence took place on 3/4/2017 at about 1:30 p.m. After returning to my house, I saw my father was sitting on pidha, and one female child was lying in front of my father, whose mouth was gagged by white cloth, and she was trembling, and blood was oozing from her left hand. On seeing the same, I tried to rescue the said girl from the clutches of my father, and after rescuing her, I came to know that said girl, namely Jasmine Sutar, who was the child of grandfather of my elder father, and also found blood in a small bowl, that is gina. Being enraged, my father dealt a knife blow, causing injury on my right hand. As a result, I became senseless. After regained my sense, I saw the said girl was lying dead there, and my father was also sitting near the said dead girl. When I asked my father about the death of said girl, my father confined me in a dark room. Thereafter, my mother and sister-in-law asked me to search Jasmine, but I could not find Jasmine. My father told me not to disclose the matter and to proceed to Chennai after withdrawing money from passbook. Thereafter, I disclosed. That is the
body.
Good. No, my lord, if also will come, my lord, and other what the other stated that we came to know that 7 तारीख पर्यंत he was there.
No, this boy is an injured, and he is the son of the. He is the son of the.
Yes, that is my.
Why you will tell falsehood against his father?
That is my submission before lordship.
Yeah.
Neither he sustained any injury.
Who has sustained it?
This boy. कौन सी prove ना injury रा? First, second your lordship turn to.
माने medical examination है ही नहीं पूछे.
ना, तारा medical examination है ही नहीं कि तारा कौन सी injury रा तारा देखना है, prove नहीं. Second, kindly see the postmortem report. Doctor postmortem report PW 9. And before that your lordship once again did that line that said देखिला जे से समय से मरी जाइछि बोली से जियो. Lordship से आउ थरे से line middle line टा पढ़ दूची. Being enraged, my father dealt a knife blow causing injury to my right hand. As a result, I became senseless. I saw the girl was lying dead there, and my father was also sitting near the dead girl. Now, my lord, your lordship, come to the postmortem report. PW 9.
Antemortem drowning.
Antemortem drowning. Cause of death is due to asphyxia. He sustained some abrasion is there, and all abrasion are also found on the body, which is a postmortem in nature.
Years, tip of nose, toe, forehead.
The girl was not dead. In the cross-examination, paragraph 2, he stated that when I saw the girl was trembling, I called my mother. So the possibility of throwing the girl into the pond while she was still alive, for which the found to be a case of drowning.
My submission before Lordship, my lord, the entire case rests on the evidence of PW1. Because all other family members, all have, including informant, all have stated that we heard from PW1 that his father
was there at that
so,
point of
that is
took place inside the house.
Yes. So, my lord, now the remaining only the evidence of PW1, your lordship has to consider whether PW1's evidence is to be accepted or not. PW1
accepted or not, we cannot give a finding in
that is
stage.
My lord, kindly have a glance to his evidence. On seeing the same, I tried to rescue the said girl from the clutch of first se kouchi
appears to be a child sacrifice case from the face of it. Whether it will be ultimately, whether the evidence of PW1 will be accepted or not, that is a matter which is to be finally adjudicated.
But
how can we give a finding at the bail stage that PW1's evidence is not believable?
No, because he has
then
stated,
we are deciding the appeal at this
considering
stage.
the bail, my lord, first, my lord, he has stated that I found the girl was dead.
Those things.
Girl was dead, my lord. He was dead by that time. He said that
it's not dead, Mr. Come to the point. In cross-examination, you have brought out that when I saw the girl, he was trembling, for which I called my mother. That evidence you have brought out in the cross examination.
ଚିପରେ ବି ସେଇଆ ଅଛି ତାପରେ କହୁଛି ଚିପରେ ସେଇଆ ବି କହୁଛି ତାପରେ
So-
ପୁଣି କହୁଛି ଯେ ମୁଁ ତାପରେ ମୁଁ ଦେଖିଲି ମରିଯାଇଛି ବୋଲି ଫାର୍ଷ୍ଟ ସେକେଣ୍ଡ ଲାଇନଟା on seeing the same I tried to I found one child was lying in front of my father and she was trembling and blood was oozing from her left hand मतलब fourth line टा cheap रे
You are not arguing
thereafter
a
on
matter on
seeing the
merit,
same I
Mr.
tried to rescue the
Mr.
girl from my
Jafrullah. You are arguing a bail application,
sir,
not the
sir,
appeal on merit.
but ତା ପର ଲାଇନ ଟା କହୁଛି ମୁଁ ଦେଖିଲି ସେ ମରି ଯାଇଛି ବୋଲି that is only my submission.
Are the learned counsel for the petitioner, learned counsel for the state, in view of the age of the deceased and the eyewitness account of PW1, who is none else than the son of the appellant, and the manner in which the crime has been committed, so also the postmortem report finding, we are not inclined to release the petitioner on bail, stands rejected. Yes, next.
May I pray, my lord? But already
No,
in
no, you
custody.
wait, you were 7 years. There are
Aye.
very old appeals are there. It's a 2019
19.
appeal.
My lord.
No question of advancing, giving preference to the hearing of the child sacrifice case. It appears to be final. Yes, next.
Item number 25.
Mr. Sahu.
Instructions for lordships.
Custody certificate and the mental condition of the accused was called for, and also the
You have brought it.
Okay. Yes, status of the PW1 11, the eyewitness matter. That part is not obtained, but custody certificate and mental condition of the accused.
Just to let us see the order. Last order के बेचला.
11 sir.
कहीं से order कहीं? Scanning ही नहीं की से order टा. दियम से order टा दियम. आज scanning करी हुए order हाँ? Petitioner is in judicial custody, so and so evidence of PW7, which indicate petitioner having a psychiatric problem and he was under medical treatment. After initial health condition of the petitioner through the concerned jail superintendent, produce the custody certificate along with the criminal antecedent if any against the petition, the family background of the petition and the status of the sole eyewitness. Sole eyewitness or status कौन पे हमें? कौन की
I
PW
tried to contact that ISC Telpe, but couldn't.
नहीं कौन पे वकील कौन मैंने PW
ଛୁଆଟା
या पिला against कोई थला ना कौन?
ନାଇଁ ସେ ମାମୁଁ against ରେ କହିଛି ସେ ଆଈ ଘରେ ରହୁଥିଲା ଅଜା ଆଈ ଘରେ ଛୁଆଟା
अच्छा वो ता निजर बापा माँ मर जाइछन्ति.
that part I do not know, but instruction was
कौन पे उठे कारण थियो ना. Status of the sole eyewitness. देखिए PW
11.
PW 11. এটা হচ্ছে 15 বর্ষ. তার নাম হচ্ছে নিমা মুন্ডা. I know the informant, I know the accused standing in the dock, who is my maternal uncle. Acha. I know the deceased, who is my maternal grandmother. At the time of occurrence, I was in the house of my maternal uncle, reading in class 4. The occurrence took place at about 8 a.m. At the time I was present in the house of my maternal uncle with my maternal grandmother and so on. So at that time I was taking rice for eating. My grandmother was preparing sago. By that time the accused dealt axe blow on the neck of my maternal grandmother and she fell down with severe injuries and she was chatpat utracha. I ran away from the spot out of fear and went to the house of Shankar Munda. After hearing the incidents also. ଆଚ୍ଛା ଏଇଟା ଚତୁର୍ଥରେ ପଡୁଥିଲା ସେତେବେଳେ ସେ କହୁଛି ଘଟଣା ବେଳେ बयस डिपोजिशन बढ़ी 15 वर्ष स्टूडेंट लगी 5 वर्ष 5th क्लास स्टाटस टा मगुथे बोधे बापा माँ आसी मामू घरे कौन पे रोला बापा माँ मर जाइए ना कौन मे बी दैट से दिन आम ये जाइए गले से जदि पहुँचो से एकुटिया रोचे से झील कारण आई मरीगला ये मामू आसला भितर को से झीलटा कौटी रोचे कौन कौची ए सब जिनस स्टाटस टा मगेइथिलु you have sought for that insurance
It a mental condition of the appellant as well as the petitioner.
खाली स्टाटस टा आनिबे
Status of C.Dash.
तो स्टेबल लिखा इज तो हेल्थ कंडीशन इज स्टेबल कस्टडी सर्टिफिकेट केते देखुची
9 years 1 month. 3350 days.
देखो as per the order dated 1/7/2024 এটা লিখবে IN number 1612 of 2019 as per order dated 1/7/2014 the Learned Council for the state has produced the custody certificate so also the health condition report of the appellant which is taken on record. The Learned Council for the state, however, submits that as per the said order, he is to produce the status of the sole eyewitness (PW 11), and he may be given some further time in that respect to obtain instruction. 29th put up this matter on 29th July 2024. Yes. Then hearing matter. Advocate अछंती तो नवीन देवरी और सबको ठीक है yes Mr.
Lordship has
Please
seen,
adjust the
Lordship has seen the report that has been submitted. The background is this. Only 2-3 instructions.
No, what the report? Let us see that report. Have you got the copy of that?
Yes.
One affidavit has been filed by the Senior Superintendent Circle Jail Sambalpur.
Yes.
He is Mr. Anil Kumar Sahu.
Right.
What he has stated there?
He has only shown the affidavit relating to the conduct and the report of the probation officer relating to the history of the
so he collected this. Then, acha, you come to the sub paragraph that page 2.
Right.
See you.
Hence, basing on the aforesaid documents, the deponent most humbly submits that the accused Nobin is not involved in any other case except involvement of the accused in Moholapalli PS case number 134 dated 6/11/15 registered for the commission of offence punishable under section 379/34 of IPC, which is pending trial. The conduct of the accused condemned prisoners Nabin Deuri and souls of the co-accused Heman Deuri have not committed any jail offense during their confinement period in the said jail. It is pertinent to mention here that the aforesaid reports show the past life period, psychological condition, and post-conviction conduct of the appellant, copies of which are
Here,
annexed.
both have been sentenced to death.
No.
Okay. Nabin Deuri. Okay.
So far, during jail conduct, they say they have not committed any offense while.
Okay, now the other reports which are annexed to the
Yes, Lord.
that report.
The first report is that of
regional probation officer.
Yes.
Yes. What he has mentioned?
With reference to the above letter on the subject addressed to the District Probation Officer Sambalpur and discussion over phone dated 1/7/24 with Senior Superintendent Circle Jail Sambalpur, I proceed to village Lapada, PS Mohupal, District Sambalpur to collect information with regard to past life history of the convict Nabin Deuri of Circle Jail Sambalpur on 3/7/24. Contacted the neighbors of that village, namely
Yes.
Nabin Ratha, Sanjay Nayak, Manju Maji, Anganwadi Karmi, along with Sarpanch, namely Labanya Nayak, and her husband Ramesh Nayak, as well as ward member Madan Kishan, to collect information about the convict. It is known from the neighbors of the convict that the convict family is comprising of his wife, one daughter, and two sons. The daughter is the elder one, who has already got married. Out of the two sons, younger one is dead. The second one is in jail custody at present.
That is at Hrudananda. Yes.
On the same case, it is found that the dwelling house of the convict is completely demolished, and it is known from the neighbors of the locality that his wife is residing at her father's house. After the arrest of the convict, the cell phone number of convict's wife is collected from the immediate neighbor of that village, and the wife of the convict is contacted over phone. As per the statement of neighbor, Sarpanch, ward member, and his wife, prior to the imprisonment, the attitude, conduct, and behavior of the convict was very good and fine. He maintains good and amicable relationship with the people of that locality. No adverse remark is passed by any of them. All the close neighbors of Navin Deuri, along with Sarpanch and one member, are further interacted. As for their statement, it is known that the land disputes between the convict and the deceased family is one of the prime reason for not having good relations between them. They also reiterated that the land disputes between these two families were very acute, which has been noticing over years together. It is also stated that ancestral property of the convict was encroached by the deceased, for which most of the times the convict became upset for depriving of his ancestral property. Besides, deceased teases to convict several times to create an unhealthy situation. Most of the times, the convict becomes upset and teasing attitude of the deceased. Besides, the wife of the convict also expressed that due to land disputes, conflicting situations between the two families were a regular phenomena. She also expressed that due to land dispute, the convict was not remaining in a constant state of mind. He was always taking psychiatric medicine, suffering from mental trauma.
So it is a teasing attitude of the deceased. Ancestral property saityo. Upon the case ki konda kohuthila bodhe. Beside the deceased teases the convict several times.
One line I will add, your lordship can also take note of it. I have taken instruction that land is to one land. Property is same place. He lost encroached and then won the case. 5 acres.
Who won the case?
The deceased.
Acha.
जो केस को जनते अमनारी डिग्री ही 5 acres he lost. So major part of his land were lost. Because of that, after his daughter's marriage, his condition was not good, financial condition. The son is also working elsewhere, and that is how they survived. And the teasing continued, and the quarrel was a regular phenomenon.
No, this What about the challenging that order which was passed in?
No, because of his financial condition, he
Oh,
could
he did
not
not
achieve
challenge.
anything. And even in the statement, there is some material that
Okay, and what are the other documents?
he used to state in the village that by fraud they have taken away my land. That is his belief.
Okay,
that is the state of mind.
please come to the Bhimsar Burla Sambalpur's report. What is there in that report?
This report, what I gather, the relevant thing is the page 7, page 6. They also certify the same thing that he was under medication for more than 5 years.
5 years, 2 months with medication, and for what?
Psychiatric.
Sure.
Even I asked the local council to inquire exactly on that day what happened. He doesn't remember anything. So that part I am clueless.
No, you come to the this report which has been furnished. Column number that 5. When asked about your future plan, are you having that copy with you? 5 number ta. हेडिंग करनी 1 2 3 4 करी 5टा होची सेई जो ये सर्टिफिकेट आपनकर भीमसार रो जो सर्टिफिकेट देइचंती तारो सेकंड पेज रे अछि 5 नंबर बोधे सेटा कोन गोटे लेखा है जणा पड़ुनी किंतु लेखा है पर्सनल when asked about file.
So, an average built male, middle person.
No, second page of that report.
Yes.
First page second of is the Bhimsar Burla Sambalpur से जो emblem अच्छी गला second page को पढ़ जाएंगे. Second page
टा cannabis consumption.
हाँ second page टा जो start है ये तादरे विभिन्न column नहीं 3 4 number गोटे कौन दिया है जी तापर then 5 number गोटे आछी. Personal when asked about the future planning, he says that after relief, he will cultivate his land with water and harvest. Personal file.
But I have seen that.
Personal ଲେଖା ହେଇଛି ମୋ
ଆଉ ପାଞ୍ଚଟା ଲେଖା ତା ପୂର୍ବଟା ହଉଛି an average male looking appropriately tough, kept, groomed, appropriately dressed according to hospital setting. Touch with surrounding is present. Eye to eye contact established and maintained. Rapport was established easily. Posture, sitting comfortably and calmly on chain, maintaining eye contact, in touch with the surrounding. I mean, he was normal. Attitude towards interaction was cooperative. Psychomotor activity is normal. Voice and speech intensity was audible. Normal pitch. Relation time was normal. Speed was normal. Case of speech is normal. Relevant, coherent. Good goal diameter. Productive was normal. Relaxed manner with no diverse deviation. Mood. ମନଟା କେମିତି ଅଛି ଝିକୁଛି. Affect was aesthetic. Thought stem is normal. Orientation oriented to time, place, person, date, month and year. जब डेट पर पचारले कहि पड़तले. Attention and concentration tested with digit span test. Forwarded up to 5 digits and backward up to 2 digits. Patient was able to tell 20 to 1 in 50 seconds. From thus, I infer that attention and concentration is impaired.
ତାପରେ ଆସିଛି ଭୀମସାର ବୁର୍ଲାର ଏ ଯୋଉ
memory.
Memory ଟା state to 1 to 5 ଯାଏ କହି ପଡୁଛି ମୁଁ ଓଲଟା 2 digits ଯାଏ କହି ପଡୁଛି
ତାପରେ ଯୋଉ ରିପୋର୍ଟ
20 ରୁ 1 ଆସିଲା ବେଳକୁ impaired କରୁଛି 15 second କରୁଛି memory immediate was in next page was memory immediate was intact and tested with 3 objects. Recall test was able to recall without need of parroting. Recent memory. Patient was able to tell what all he had in food in last 24 hours, which was corroborated with his attendant. From this, I infer recent memory is intact. Remote memory. Patient was able to tell names and ages of all his family members, date of birth of his child. From thus, I infer remote memory is intact. General information. General information was inadequate as patient was not able to tell PM, rice price and seized fruits impaired. ଭିତରେ ଗୋଟେ କହିପାରିବି
ଏଇ ତାପରେ ପଳେଇଲେ ସେ ଯୋଉ ତାପରେ ନେକ୍ସଟ ପେଜ ର you come to 5 number ଟା
Question wise was the question.
question
No. He do when he feels cold.
फाइंडिंग तो ଦେଇଥିବେ अल्टीमेटली ये जो पर्सनल ताको पचरा ହେଇଛନ୍ତି 5 नंबर कॉलम रे ସେଇ ଆଉ ଟିକେ ତଳକୁ
personal when asked about his future plan he said that after relief he will cultivate his land with water harvest. Personal judgment is intact. Then social judgment personal judgment is intact. Then social judgment, patient interact well with doctors and staff according to every order in his and in exam room. Social judgment is intact. Finally, it is the outcome. Social judgment is intact. When asked what he will do when he see a train track derail while arrival of train is already announced, he said he will just pass through it. At present, mental status examination and my behavior observation patient is no psychopathology at present and is on remission in antipsychotic.
We'll continue after lunch, Mr.
Yes.
My lord. Yes. Item 59 can you taken up?
59?
Can you taken up? Thursday or Friday?
Why are you mentioning?
I appeared in custody more than 16 or 1.
No, everybody must be in custody or bail. You want it to be taken off? Jail criminal appeal?
No, CRL. 59 ones. Last item JCRL 48/17 your lordship granted bail 24/4/24.
This is for hearing.
My lord.
So there are other connected appeals also.
My lord.
You are in which item?
First item 3/12.
You call the other counsel so that everybody should come and take up. Will take up. We cannot hear.
Item number 3.
This is all the report, and evidence only suggests one thing, that previously he was also telling in the village that he will kill. Now, my lords,
You are facing that report.
that's overall what comes to picture.
Just 1 minute. Present health condition, so also is normal. What about his behavior inside the jail?
Is good.
Okay. And that good one case is there, that is 379, which is okay.
379.
Now, what are the citations you have relied on this number of murders, that that apart from that case which I think 95
OCA.
there is
Then 2 other cases the other day I pointed out. Only that number of persons murdered is not the determinant factor. Other circumstances are to be kept in mind.
let us see that decision again.
It's a joint property held by both, separated by village entries. One brother wanted to take a loan by mortgaging that property because it's a joint family property. The other brother did not did not agree to. A village meeting was called where he was asked to hand over that property. Immediately he comes and kills 3 of them.
3 and 1 was injured also in that case, I think.
3.
The 307 charge is also there, I think. This is 95 OCR the law.
This is a flag right. ଦେଖାଗଲା
ସେ ଯୋଉ ଇଏ ଖାତାରେ କଳା ଖାତାରେ
ମୁଁ ଯୋଉଟା ମାଗିକି ପଢୁଥିଲି ଏଇଟା ଜଷ୍ଟିସ ଚାଟାର୍ଜୀ କରିଥିବ
The father was injured and the 2 sons and daughter, all 3 were murdered.
ପାଇଲ? ହଁ ଦେବେନ୍ଦ୍ର देखिए पेज नंबर कितने?
Page was 435. 435.
1995 volume 8
OCR.
OCR 435 लिखी तो गई देवेंद्र प्रधान एटा फैक्ट टिके पढ़ देले आतो देखो पैराग्राफ अच्छी बहिटा
ठीक अछि paragraph 2 plus
paragraph 2 पढ़ो
so DK Mr. And SC I appeal for the state. The prosecution case is that Sanatan Pradhan, son of Kamal Lochan Pradhan,
aged 58 years. Upendra Pradhan, son of Sanatan Pradhan, aged 18 years. Devendra Pradhan, aged 20 years, son of Sanatan Pradhan. Jemade Pradhan, wife of Sanatan Pradhan, aged 48 years. And Rabindra Pradhan, son of Sanatan Pradhan, aged 24 years. All residents of village Basiapada, PS Jujumara district, Sambalpur, stood charged with offences under section 307 and 302, related to section 34 of the Indian Penal Code, for having attempted to commit murder upon Vrindavan Pradhan, PW7, and murder of his two sons and one daughter, namely Sanjeev, Rajiv, and Prabhasin, aged about 11 years and 7 years respectively, in furtherance of their common intention. Sanatan and Vrindavan Pradhan are two brothers having title deeds of their lands standing in their names jointly. They were, however, separate in mess and properties by an amicable partition. Before 27th August 1993, Aiku Sanatan asked Vrindavan for the potta of the lands to procure a loan. The potta having been with his mother, Vrindavan refused to give the same to him. Aiku Sanatan was annoyed and declared to cut the members of his family into pieces and ruin his progeny. Vrindavan, for fear of life, left his ancestral house and stayed in the house of one Keshav Pradhan of his village till 29th August 1993. Panchayat meetings were held to decide the dispute between them. On 27th August 1993 and 29th August 1993, and the second day's meeting settled the dispute compromise in view of the undertaking given by Vrindavan to supply a potta to Sanatan within 10 days. At about 8 p.m. of 2nd August 1993, Vrindavan returned to his house with his wife and 3 children. The husband and wife holding lanterns, since the apprehension and fear were removed from their mind after compromise. At their sight, Aiku Sanatan was played off, and both Sanatan and his wife, Aiku Jemade Pradhan, called out their sons, the other accused, namely Upendra, Devendra, and Ravindra, to cut the family members of Vrindavan into pieces and to end his family. No sooner than Vrindavan entered his house and asked his children to follow. Accused Ravindra, Devendra, and Upendra came to him with axes and lathi. Accused Ravindra dealt 2 blows with his axe on the neck and head of Vrindavan, and Devendra dealt a blow with his axe on the head of Vrindavan. With profuse bleeding wounds on his person, Vrindavan grovelled into the nearby house of one Kulamani Budhia and there became senseless. Accused Upendra and Devendra then caught deceased Sanjeev, Rajiv, and Prabhasini, and accused Ravindra gave axe blows on their necks and other parts of the body. The mother of the said children, P1, stood at the sight being dumb. She screamed aloud, and the villagers came there to see the dead bodies of their children. The Sarpanch of the GP, getting this alarming news, called the police from Jujumara PS. P1 lodged oral report with police on which investigation ensued. After charge sheet and commitment of the case to the Court of Session, trial of the accused was held.
I have come to the discussion about this death sentence of case के day. It's 439 for
17 plus paragraph 17.
Paragraph 17.
17 plus that is at 449.
17 though?
Yes, plus 17. There we have gone through the materials on record very minutely and have tried to feel the gravity of the same.
True it is that.
True it is that there was a great tragedy happened in the life.
Paragraph number
15.
15 about.
Regarding had to the materials on record, the learned advocate for the appellants has also argued with regard to the scope of punishment. Attention to the court was so drawn to the principles laid down in A 1980 Supreme Court Singh v. State of Punjab. It has been observed in the decision at page 944, para 304, that the mitigating circumstances have to be taken into account by the court while considering the sentence of death. Our attention has also been drawn to the decision reported in A 1989 Supreme Court 1456, Alauddin Mia v. State of Bihar. In that case, 2 girls of 7 years and 7 months of age were killed where the motive for crime was obscure. The killings were not for gain, and mere fact that infants were killed without more was not sufficient to bring the case within the category of rarest of rare cases. Another decision was cited, which is reported in 1991 for CCR 619, State versus Setalu Sudan Reddy. In that case, a young girl of 6 years was lifted from the village road and brutally killed. There was death sentence, but the same was converted to imprisonment for life. The reasons indicated therein were that there was emotion and mental disturbance. Similarly, in the case reported in 1994 7 OCR, State of Orissa versus Subhash Joshi, where a boy of 7 years was kidnapped and killed, the sentence of death was converted to life imprisonment. Our attention has also been drawn to the decision reported in the year 1978 Supreme Court 274, Sri Rangan versus State of Tamil Nadu, which was a case of triple murder. The accused was found to be young in age and in a state of frenzy. The offense had been committed. Death sentence in that case was reduced to life imprisonment. We find also in the case reported in year 1971 Supreme 1388 Om Prakash versus State of Haryana that the imposition of death sentence was held to be excessive when two co-accused who were alleged to have instigated the accused to fire at the recess were given benefit of doubt. In another case, 1994 SCC 323, Barlas versus State of UP, there were murders of the brother, his two children, and their friend, and the offense was committed under influence of extreme mental and emotional disturbance. Innocents were killed, and the murders were found not cold-blooded. The accused was found to have acted in a frenzied manner, and the sentence of death in that case was reduced to imprisonment for life. 1994, Volume 3, Crime 619, M.S. Sesapa versus State of Karnataka, was a case where the accused was alleged to have killed his parents, brother, and sister-in-law, and was aged of 32 years. There is no evidence that he had pre-planned the series of murders. He appeared to have been obsessed with some ideas. It was held to be a case of extreme mental and emotional disturbance, and the death sentence was converted to imprisonment for life. Similarly, in 1994, SCC Criminal 629, Bithal versus State of Maharashtra, the accused had committed murder of his brother's wife, inflicted injury to his father and brother, and also killed a 7-year-old boy. Participation of the accused in the crime was proved, but the motive was clearly established by the prosecution. Death sentence in that case was found not justified and was reduced to imprisonment for life. Maybe motive was not clearly established, I think. Yes. On the converse, the learned additional standing counsel.
You come to paragraph 70.
Yes. We have gone through the materials on record very minutely and have tried to feel the gravity of the same. True it is that there was a great tragedy happened in the life of a helpless father and crying mother. In their very presence, their 3 young children were brutally murdered. Since they had the apprehension for life, they had to leave their residential house and take shelter at a house of a villager named Keshav Pradhan. Only the compromise had convinced them that they could come back to their own house. Unfortunately, Sanathan's anger didn't extinguish. He flared up the site of Pedal 7. Yes, yes. The site of Pedal 7, returning with Pedal 1 and the children. It is proved that Sanathan, being the eldest member of the family, instigated his 3 young sons to commit the crime. Being instigated by their father, his sons forcibly made their entry into the house of Pedal 7, assaulted their uncle, and killed the 3 innocent children.
Like hungry wolves.
Like hungry wolves. The part played by Sanathan is beyond comprehension, but it appears that he has acted under an emotional outburst. Without understanding the consequence, he instigated his young 3 sons, but didn't realize the consequences of the heinous offense going to take place. The instigation was sufficient enough to excite the accused sons to commit the crime. Appellant Rabindra, being very young in age, was found to have been more emotionally excited, and he hit all the 3 children by his axe, causing their death. All these actions have been committed under grave
what I remember, that's what was quoted there.
Yes.
By the London trial court. Asileni Maro Solakuna Kono Dekiva.
Yes.
That is the father
Instigate the instigation. Yes. Yes.
That language has been quoted in inverted comma by the trial court. Actual language.
Come in the evidence.
Yes.
So the kind of instigation inside it.
Yes.
Yes. Please.
All these actions have been committed under grave emotional disturbance and in great frenzy. The crucial moments of tragedy taking place. The Supreme Court, in one of the judgments reported in year 1980 Supreme Court, Supra, has held certain salient features to be considered in inflicting death sentence. The Supreme Court has held that the provision of death penalty as an alternative punishment for murder in Section 302 IPC is not unreasonable and it is in the public interest. It can be held that the provision in Section 302 violates neither the letter or the ethos of Article 19 of the Constitution. In that case, the constitutional validity of Section 302 read with Section 354, that was under challenge. It can be held that the provision in Section 302 violates neither the letter or the ethos of Article 19 of the Constitution, but certain mitigating circumstances have got to be considered. In para 204, at page 944 of the decision, the Supreme Court has quoted certain suggestions made by Dr. Chaitali as mitigating circumstances. In the exercise of the discussion in the above cases, the court shall take into account the following circumstances: that the offense was committed under the influence of extreme mental or emotional disturbance,
which is
not
just
available.
contrary to
Yes.
Cold-blooded murder.
Yes. Yes.
Cold-blooded murder ଆଉ ଜଣେ ହଠାତ୍ ଗୋଟେ ଇଏ
Yes.
ହବ that
Yes. The age of the accused, if the accused is young or old, he shall not be sentenced to death. The probability that the accused would not commit criminal acts of violence as would constitute a continuing threat to society. The probability that the accused can be reformed and rehabilitated. The state shall by evidence prove that the accused doesn't satisfy the conditions 3 and 4 above. That in the facts and circumstances of the case, the accused believed that he was morally justified in committing the offense. That the accused acted under the duress or domination of another person, and that the condition of the accused showed that he was mentally defective and that the said defect impaired his capacity to appreciate the criminality of his conduct. The Supreme Court has unequivocally observed that nonetheless, it cannot be overemphasized that the scope and concept of mitigating factors in the area of death penalty must receive a liberal and expansive construction by the courts in accordance with the sentencing policy writ large in Section 343. Judges should never be bloodthirsty. Hanging of murderers has never been too good for them. Facts and figures, albeit incomplete, furnished by the Union of India, show that in the past courts have inflicted the extreme penalty with the extreme frequency, a fact which attests to the caution and compassion which they have always brought to bear on the exercise of their sentencing discretion in so grave a matter. It is therefore imperative to voice the concern that courts, aided by the broad illustrative guidelines indicated, will discharge the onerous function with ever more scrupulous care and human concern, directed along with the high broad of legislative policy outlined in Section 323. That for persons convicted of murder, life imprisonment is the rule, and death sentence is an exception. A real and widening concern for the dignity of human life postulates resistance to taking a life through laws instrumentality. That ought not to be done, save in the rarest of rare cases where the alternative option is unquestionably foreclosed. Judging from the said angle of vision, although we deprecate the offense committed by the accused, yet there is a great saying that to lose faith in humanity is a sin. It must be appreciated that there is still life in life sentence and only death in death sentence. There is a great saying also that it must be a human endeavor to hate the sin and not the sinner. Relying on the ratio of the decisions of the apex court as discussed above, we find that the ends of justice should be met in the present case if instead of confirming the death sentence, it is reduced to imprisonment of life. The criminal appeals are allowed in part. Yes.
and now in view of the latest Supreme Court decision, we are calling for those background, this conduct in jail after the occurrence, every details we are apart from his mental condition that has also to be taken into account. One thing they have stated, I think that that giving life imprisonment would be not meet the ends of justice. I think that it is
That has to be defined.
yes, that has to be defined. That it is such a case where if you give the life imprisonment,
inadequate.
that would be squarely inadequate. That means the only sentence which can there is no chance of reformation.
Yes.
He
is a menace to society.
Is a menace to the society. But if there is still some hope that he let him just live the life, he may not be totally. He may not come out of the jail.
That was the legislation when 74 CRPC came. It was reversed. Special legislation came into after 74. So that was the legislation. That was the legislation thinking behind it. Then
a type of threat against the nation.
Yes.
Gote iye padila ba gote extreme iye koraichi jota ki emti
Extremely brutal.
It মানে death sentence ଦେଲେ during that ଏଟାକୁ ସେ କିଛି reformation ଦେଖଉନଥିବ ମାନେ ସେଇ ଯୋଉ period
had killers. Worse are the habitual hired killers.
Maybe.
Because they have nothing to do with what they have done. They are doing it
for gain.
For gain.
For gain. This case is a case where the dispute is
individualistic.
Property ପାଇଁ dispute ଅଛି ଏବଂ ଯାହା evidence ଆସୁଛି ଯେ କିଛି teasing ଇଏ deceased own କରିଛି court of law ରେ ତାର win କରିଛି case ଏବଂ teasing ଦଉଛି ବୋଲି ଯୋଉ ଆସିଛି ଆମର reports.
Rightly or wrongly, this fellow believed they have somehow gained over the authority and
challenge
so
financial
he could not. Then another son's death before this, then financial condition, then one patch of the land, and evidence indicates it was paddy crops were half caught, half was there. So seeing the things, and when somebody else teaches you,
on the one side we have to keep that it is a case of triple murder.
Yes.
And out of the three, two are ladies.
Yes.
That I am Miller's. I have an answer for that. Though Girisar is the male deceased, he is the person who was cultivating or doing it, or the incident happened. But teasing, when his wife says they are teasing, means it's common. The other ladies might be also involved. It's not natural. Being neighbors, teasing is not basically by the main persons alone, rather more by the female persons. Second biggest reason is they are the inheritors. The mother and daughter, though they are ladies, but they are being targeted by this man because they are the real property inheritors. The main thrust in his mind to get rid of them. Yes. No, they already he lost. The land belongs to the Piravati, the mother.
Yes.
Giridhar is the son-in-law. So the real property inheritors are the mother and daughter. So he has not killed their ladies or anything, or he has not left. They are the inheritors. So the nexus is maybe difficult. Get rid of the persons who he felt have taken over his land by some
one thing that he has lost the property, number one. Number two, this teasing.
Teasing in the report.
Overall, Milord.
In the report, Milord. Not in the evidence.
Totally ignore
hearing on the question of sentence, strictly Evidence Act is not applicable. Hearing on the question of sentence, Evidence Act is not strictly applicable. So evidence not be taken like evidence is taken in normal course.
ସେଥିପାଇଁ ତ ସେ law ଟା let down କରିକିନି ସେଥିପାଇଁ ତ ଆମେ ଯେ କହିଲେ ଯେ
one Millers,
you are to call for these reports.
Yes. One, it's not a pre-planned murder. He is not a habitual offender. His conduct is individualistic. He has nothing to do with any of the villages, nor anybody else, excepting this family has a grievance against him. Even while he went back, never tried to attack the children and other things. Thereafter, they went back. He could have tried. Simply, he walks back to his house, remains there till police arrives and takes him.
There are other family members who are the eyewitnesses to the occurrence.
He could have attacked them, chased them, continued with the thing. So somehow his target was that, and the ladies, because they are the inheritors. Property goes to Pirovati, then his daughter. Because he doesn't have a son. He is a Elotom son-in-law, 2 daughters only.
And
so they are the inheritors.
After what has happened, Mr. Kotkia, ସେଇଟାକୁ ମଧ୍ୟ ବି କନସିଡର କୁ ନବାକୁ କୁହାଯାଇଛି ସେ ଡିସିସନ ନା ଯେ ତାର ପୁଅ ଯୋଉ କଣ୍ଡକ୍ଟ while in custody subsequent ତେଣୁ ଆପଣ ଯାହା ରିପୋର୍ଟ ଆଣିକିନି ଆମକୁ ପ୍ରଡ୍ୟୁସ କଲେ nothing adverse is against him, his behavior in the jail
solitary confinement ରେ ତାର ସେ solitary because in a death sentence he is being kept away from other convicts ତାଙ୍କ ସାଙ୍ଗରେ ମିଶିକି ରଖନ୍ତିନି
ନା ସିଏ ରଖୁଥିବେ କି ନ ରଖୁଥିବେ ଯେମିତି solitary confinement that has been
provision ଅଛି ନା କେତେ ଦିନ ରହିବ କେତେ ଦିନ ବାହାରିବ
it should that was be challenged also. The Supreme Court said you cannot keep such a person in solitary confinement.
ସେଟା ନୁହଁ they are kept away from other
he'll be in different state
solitary confinement ମାନେ ଆପଣ କୋଉଦିନ ପୁରା ଦମ ଗୋଟେ
ସେଇଟା ନାହିଁ ସେଇଟା
nobody will see
ସେଇଟା ପୁରା ଦମ
solitary Andaman re never immediate person who is staying there for the decades, you won't know who is there in the other room.
From that report indicate that his behavior towards the others is good, I think.
Yes.
So that means he was allowed to interact with them or mix with them.
No, the behavior towards the person with whom he was interacting at that particular time.
Please come to that report. I think he somewhere it is mentioned.
The doctor says in the cell, in the hospital, everywhere his behavior is good here. There is nothing
the
adverse.
Conduct of the accused condemned witness Navin Devri and so also the co-accused Amananda Devri have not committed any jail offense during their confinement period in the said jail. It is pertinent to mention here that the aforesaid reports show the past period in psychological condition and post-conviction conduct of the appellant. So nothing adverse.
No, nothing adverse. Nothing adverse.
We can't say that that is good, but nothing adverse.
ତା ପୂର୍ବରୁ ମଧ୍ୟ ଯୋଉ ଘଟଣା ପୂର୍ବରୁ ଯାହା ସେମାନେ କଲେକ୍ଟ କଲେ as per the statement of the neighbor, ସରପଞ୍ଚ, ward member, ଏମାନଙ୍କର ଥିଲା ଯେ attitude, conduct and behavior of the convict was very good and fine. He maintains good and amicable relationship with the people of the locality.
Yes, no adverse remark is passed by any of them.
Only it is because of this property dispute that he committed this.
Yes, no, that is the reason. That is the motive.
Backed by what has been done, that teaching property.
And for that also he is medicated. That's the wife's information. And the doctor also says he has a history. Because he is taking medicine, he is fine. If doesn't take, may.
The land dispute between two families was very acute.
Yes.
Which has been noticing over years together.
Yes.
And it is also stated that ancestral property of the convict was enclosed by the deceased, for which most of the times convict become upset for depriving of his ancestral property. Besides, the deceased teaches to the convict several times to create unhealthy situation. এই যে কোন কোর্ট জিতি গলু দে এই টাইপ ର এই ସି ପ୍ରପର୍ଟି ଯାଇଥିବ ଆଉ ଏଇ ଯୋଉ ଟିଜିଂ ଯୋଉ ଆଟିଚ୍ୟୁଡ ଲେଖୁଛନ୍ତି
and because of his inability to fight them in a forum or he ultimately compelled him to do it himself.
No, there is no evidence that he has challenged the order. That is all.
But the competent court of law has passed the decree.
Yes.
I said he remained in a belief.
Challenge କରିଛି ବୋଲି କିଛି matter
ନାହିଁ.
ଆମେ ଏଠୁ ବାହାରିଲେ ବହୁତ ଲୋକ ବିଲିଫ କଣ ଜୀବନ ଦେଖିନ ଓକିଲାତିରେ କ୍ଲାଏଣ୍ଟ କଣ କୁହନ୍ତି କଣ ହେଲା ରେଜଲ୍ଟ ନେଇକି ତାଙ୍କ ଅନୁସାରେ ତାଙ୍କ ବିଲିଫ.
Normally they do not know the consequence of such a thing. If the persons are wiped out, it is because of the case of the senior's nature. They are even not entitled to be the inheritors.
I was interacting with the jail superintendent. Well, what is his condition? Just plus out of the court, with due apology. He said they know that yes, no death sentence is being confirmed in the High Court. That's the reason they are very casual.
No.
That every prisoner should.
Yes, yes.
But my instruction is, he asked him exactly what happened on that. He said, I don't remember anything.
He was always taking psychiatric medicine, suffering from mental trauma.
But this is not backed by court. Is it? In the IMSA it is there.
Yes,
No,
he have
no psychopathic.
Psychopathic is
no. He is taking medicine. He is fine. But medicine is obviously for a defect.
Medicine.
Not that voluntarily.
Medicine ଲେଖା ହେଇଛି.
Medicine ଲେଖା ହେଇଛି ନା ଏଇ ଯୋଉ medicine
ତଳେ ଲେଖା ହେଇଛି. No psychopathy at present and is on remission in antipsychotic.
Oh,
ये fast page ରେ ଲେଖା ହେଇଛି.
10 page number 10.
हाँ ये ଶୋଇବା ପାଇଁ ଆଉ କଣ?
ହଁ sir.
5 mg 20.
ପାଇଲା ପରେ ଯେ ତାକୁ ନିଦ ହବନି.
ଏଟା ପ୍ରଫେସରଙ୍କ ରିପୋର୍ଟ ନା
ଆଜ୍ଞା
ଡିପାର୍ଟମେଣ୍ଟ ଅଫ ସାଇକୋ
HOD ରିପୋର୍ଟ.
ରାଇଟ୍ HOD ର ରିପୋର୍ଟ. ଲେଖିଛନ୍ତି ମଧ୍ୟ previous medication history of 5 years.
Yes,
2 months.
First page it's there.
With
That's
medication and some.
5 years means it goes back to the.
No. I guess it's after.
No, it goes back to the before the period of incident.
No. ये जो माने ये जो date of treatment का
9/7/24
हाँ ପୂର୍ବର 5 ବର୍ଷରୁ ମାନେ 19 ର ଆସୁଛି ଆଉ 2019 ରିପୋର୍ଟ ଦେଖି
19 ରେ ଘଟଣା କେବେ
ଘଟଣା 2020
ସେ ତ ମୁଁ କହୁଛି it goes beyond that. Incident is 20. Incident is 20. So that symbolizes
incident ସମୟରେ ମଧ୍ୟ ଯଦି ଏଇଟାକୁ ଇଏ କରାଯିବ incident ସମୟ ମଧ୍ୟ ଖାଉଥିଲା.
Yes.
Mr. Katkia, have you given any citation on death sentence?
I'll give the judgments.
हाँ नहीं ये जो multiple murders
yes
हाँ. Now we are to close it today.
Yes, sir.
It's ready.
We'll keep it on day after tomorrow.
Spiral binding kori aanichu.
For judgments.
No, kichi nahi. We can keep it day after tomorrow just for this judgment. Why we'll write from today the CA it is reserved. No, give it. We can finish it or we can close the on Thursday itself with the citations. Or what do you want?
No, if Lordship will hear this matter, I'm ready. I think it will be finished.
No. Do you want to place all those decisions?
Relevant paragraphs.
Relevant paragraph placed.
Then I have to discuss regarding aggravating circumstances, the criminal test, crime test.
Then if you are ready, then you can place it. Otherwise, it can be taken up on Tuesday. Thursday.
I'm ready, boss.
No, I thought that we just keep the books and you want to place it, all right.
So copy kori aanichu fully ready.
Please. Please.
I have sorted a copy.
No, it's all right. Just because on merit we have already heard from both this side, right?
Only on death sentence.
Only on death sentence. Because we called for that report. Thereafter, we have to hear on death sentence.
देखिए जितने हो चाहिए कि सब
Yeah.
On every judgment on the top, I have written the paragraph serials.
After the judgment.
Top, let's also come to page 1. Bachan Singh was State of Punjab.
Oh.
So first Bachan Singh ra page uchi paragraph uchi 195.
Yes.
Okay, let us go to
that. That is page 64.
64. Okay, please press.
Critically examined, it is clear that the decisions in Gray versus Georgia and its companion cases demonstrate the truth of what we have said earlier, that it is neither practicable nor desirable to imprison the sentencing discretion of a judge or jury in the straitjacket of exhaustive and rigid standards. Nevertheless, these decisions do show that it is not impossible to lay down broad guidelines as distinguished from iron case standards, which will minimize the risk of arbitrary imposition of death penalty for murder and some other offences under the Indian Penal Code. Plus, paragraph 198.
से जो ସେମାନେ ଅଛନ୍ତି ତ ସେ ଜେଲରେ ହଁ ଠିକ ଅଛି ଖାଲି ଜଷ୍ଟ ଜାଣିବାକୁ okay yes next
198 plus page 65 next page. We will first notice some of the aggravating circumstances which in the absence of any mitigating circumstances have been regarded as an indication for imposition of the extreme penalty. 199 pre-planned, calculated, cold-blooded murder has always been regarded as one of an aggravated kind. In Jagmohan, it was reiterated by this court that if a murder is diabolically conceived and cruelly executed, it would justify the imposition of the death penalty on the murderer, like the present case. The same principle was substantially reiterated by V.R. Krishna.
No, ठीक है just 198 रे कौन कहले aggravating circumstance थिबो किंतु absence थिबो mitigating circumstance ताहले तमे death sentence हला all right yes
then 199 रे कहले pre-planned, calculated, cold-blooded murder has always been regarded as one of an aggravated kind. In Jagmohan, it was reiterated by this court that if a murder is diabolically conceived and cruelly executed, it would justify the imposition of the death penalty on the murderer. The same principle was substantially reiterated by B.R. Krishna Justice, speaking for the bench in Ediganama in these terms: the weapons used and the manner of their use, the horrendous features of the crime and helpless state of the victim, and the like steel the head of the law for a sterner sentence. 201 plus paragraph. With great respect, we find ourselves unable to agree to this enunciation as you read section 354 and 235 and other related provisions of the code 1973, because in this case section 354 and section 302 that constitute validity cause under challenge. It is quite clear to us that for making the choice of punishment or for ascertaining the existence or absence of special reasons in that context, the court must pay due regard both to the crime and the criminal. But the relative weight to be given to the aggravating and mitigating factors depends on the facts and circumstances of the particular case. More often than not, these two aspects are so intertwined that it is difficult to give a separate treatment to each of them. This is so because style is the man. In many cases, the extreme cruel or ghastly manner of commission of murder is itself a demonstrated index of the depraved character of the perpetrator. That is why it is not desirable to consider the circumstances of the crime and the circumstances of the criminals in two separate watertight compartments. In a sense, to kill is to be cruel, and therefore all murders are cruel. But such cruelty may vary in its degree of culpability. And it is only when the culpability assumes the proportion of the extreme depravity that special reasons can legitimately be said to exist. This part, plus I'm putting more emphasis. Last two lines. Then paragraph 202. Drawing upon the penal statutes, the states in USA framed after Harman vs. Georgia in general and clauses 2A, B, C, D of the Indian Penal Code Amendment Bill passed in 1978 by the Rajya Sabha. In particular, Dr. Chaitali has suggested these aggravating circumstances. A court may, however, in the following cases impose the penalty of death in its discretion. Plus, in its discretion. If the murder has been committed after previous planning and involves extreme brutality. Well, I'll explain here is the previous planning and extreme brutality. If the murder involves exceptional depravity, this is all present in the present case. Or if the murder is of a member of any of the armed forces of the Union of
applicable.
Yes, plus. Yes, D. 203 plus. Stated broadly, there can be no objection to the acceptance of these indicators, but as you have indicated already, we would prefer not to fetter judicial discretion by attempting to make an exhaustive enumeration one way or the other. So we can come 205. Next page. In several countries which have written death penalty, pre-planned murder for monetary gain or by an assassin hired for monetary reward is also considered a capital offense of the first degree, which in the absence of any ameliorating circumstances is punishable with death. Such rigid categorization would dangerously overlap the domain of legislative policy. It may necessitate, as it were, a redefinition of murder or its further classification. Then in some decisions, murders by firearm or an automatic projectile or bomb or like weapon, the use of which creates a high simultaneous risk of death or injury to more than one person, has also been treated as an aggravated type of offense. No exhaustive enumeration of aggravating circumstances is possible. But this much can be said that in order to qualify for inclusion in the category of aggravating circumstances, which may form the basis of special reason, in section 354(3), circumstances found on the facts of a particular case must evidence aggravation of an abnormal or special degree.
Yes.
206 plus. Dr. Chaitali has suggested these mitigating circumstances. In the exercise of its discussion in the above cases, the court shall take into account the following circumstances: that the offense was committed under influence of extreme mental and emotional disturbance. The age of the accused, if the accused is young or old, he shall not be sentenced to death.
No,
Yes.
If
he was not under any kind of extreme mental or emotional disturbance at the time of commission of the crime, the way it has been executed, because he has killed 3 persons.
No, killed সেটাও ছাড়ନ୍ତୁ, ব্যাকগ্রাউন্ডটাକୁ ଦେଖନ୍ତୁ ଏବଂ ଯଦି he has lost the case, let us say, lost the ancestral property, and simultaneously teasing is going on. If a circumstance ତେଣୁ ଏଠି ତାର ମାନସିକ ଅବସ୍ଥାଟା ସେ ଯୋଉ କହୁଛନ୍ତି mental disturbance,
Yes.
mental or emotional disturbance, mental disturbance ର possibility ରହୁଛି ନା ନାହିଁ?
That is available, as your lordship has argued that is in Devendra versus State. That is very well available in that case, because the father has said that you go and kill all of them. They are in a way they have been disturbed mentally.
Wordings use that he ଆସିଲେଣି କଣ ଶଳା ସଫା କରିଦିଅ ଯେ ଦେଖିବା କଣ ଏମିତି
they got disturbed. In this case, what has happened, your lordship can recapitulate here, that because on the field Girdhari has been murdered, because Girdhari was going towards the village and the deceased was coming from the village towards the field. So they have crossed each other at a point where most of the occurrence has taken place. Reasonably, as your lordship can well appreciate.
So fit of anger is there.
Fit of anger was not.
Kind of revenge is there.
That is in the mind. But
where is the preparation?
That is, I'm saying that the preparation I'll show from the way he has executed the crime. Because in a nutshell, I am just placing for lordship. All the three have been killed, and they were struck at the neck, at the cervical area.
ଆପଣ ସେଇଟା ସେଇଟା କି
Yes.
ଏକ୍ଜାକ୍ଟଲି ସେଇଟା ଅଛି ଆପଣ ସେଇ ଯୋଉ ଲାଙ୍ଗୁଏଜ ଟା ତା ପୂର୍ବରୁ ଜଷ୍ଟ ୟୁଜ କରିଛନ୍ତି କୋଲ୍ଡ ବ୍ଲଡେଡ
Yes.
ପ୍ଲାନିଂ
Yes.
ଏଗୁଡାକ କୋଉଠୁ ମାନେ
I'm explaining.
ହଁ ସେଗୁଡାକ
It has come to mind. Plus, I am explaining what
it's all right. We also you have to answer that how it is you can say it to be a cold-blooded murder.
Because
planning କରି ରଖିଥିଲା ଏ କଲା ଏଇ type ର କାରଣ open street ରେ when everybody can see it ହେଲା he has nothing to hide. ତେଣୁ cold blooded planning ହେଲେ କଣ secrecy maintain କରାଉଛି ଯେ କେହି ଦେଖି ପାରିବେନି ଆମକୁ ଏମିତି କରିଦବା ଯେ ସୋ ସେଇ ଜିନିଷଟା ଏଠି ନାହିଁ ନା ଖରାବେଳଟାରେ ସମସ୍ତେ ଅଛନ୍ତି ଓପନ ଇଏରେ ସିଏ କରୁଛି ତେଣୁ that is the basic difference between.
No, plus I'm explaining with due apology. Plus the person is coming from the place. He knows, the accused knows, because it is a usual habit to go to the field in the morning, then take rest for some time, and after taking meal, they again come back to the field. This is a regular phenomenon in the village area.
Normal life of a farmer.
Farmers. So he knows that when that person is coming, the timing, and how many persons must be available there in the field, because people 5 was alone.
Normally, people are not
At that point of time, because they usually come one by one. They come by 4-5 o'clock. Many people gathered in the that field area. So he was coming. He knows that that person will come, and he has gone on the same route, because and in a crisscross manner, because he was coming from village. Also, can appreciate he was coming from the village side towards the field, and this person was going from the field toward the village. They must have crossed at a certain point. So till that point, even Girdhar is not aware that he is going to assault me, he is going to hit me. And the P5 has only heard who sound. He has stated in one paragraph, HOO, who. Besides that, he has not heard anything else. That means one blow has been given to him. Only with that sound, that person has fell down, because he has not given any reaction from his end. And there, he has struck on the cervical area. Because there, I would like to directly.
Intention to cause death is there.
Yes.
Leave it. Then.
That 3 blows have been given to Girdhari. Yes. One is enough to caught his throat.
Will take intention and knowledge.
Yes.
Then
with intention and knowledge, and that is in that way he has planned, because he has taken the axe and he has crossed him. And he knew that after his crossing, he is no more aware that I am going to hit him, because he has maintained that patience.
But axe is not
not
an instrument which is not available in the village. Normally carried by a farmer.
Yes, plus.
So there is no preparation that is.
No, plus normally
a chopper.
It is a mental preparation, plus. It is a mental preparation, because he knows that is normally available with every farmer. The deceased knows that he is coming with the axe, because normally he holds the axe. But he will hit. That is not within knowledge of deceased.
That can't be.
Yes. Because he is just coming, he is just passing through immediately, because axe that carries a handle of around 2-3 feet maximum. So with a distance of 3 feet, he is there, but this is at a distance of 2-3 feet away from the accused. So accused, after he passed him, he has given a blow, and there are 2 blows again and again. So that was my humble. There blows in the mind. He has a preparation that I will kill him here, because while passing through.
That is not preparation. That is not. That is intention. That is not preparation.
Preparation is something different. Let us say somebody to kill somebody by poisoning. Okay, he procures the poison. He mixes it to the concealing jinsa. Then execution. Preparation, attempt, execution. Time so that
him to take that place.
Others will not be aware. Secrecy maintain jinsa.
Parshansi has left enough discussion to the court.
No. Don't. We are discussing that ଏଇ ଯୋଉ ଜିନିଷରେ ସିଏ ଯୋଉ ଟାଇପ ର କ୍ରାଇମ ଟା କଲା ଏଠିକି କୁହାଯାଇ ପାରିବ କି ସିଏ କିଛି ଲୁଚେଇବାକୁ ଚେଷ୍ଟା କରିଛି ମାନେ କିଛି
brutality is there
because the mind can notice the mind what is there in the mind that successfully has concealed
mind ଟା ପରା ହଉଛି
murderer will do
yes
no murderer
mind ଟା ପରା ହଉଛି ମୁଁ କେସ୍ ଲଷ୍ଟ କରି ଯାଇଛି ଏ ଲୋକଟା ମତେ ସବୁ ଦିଳେ ଦେଖିନି କହୁଛି ୟାର ଛାଡୁ କହୁଛୁ
why ନା କଣ ଭୁଲ ହେଲା because his fault is he the son
no murderer will ask you come
yes
please come I will kill you nobody will so that remains in mind
yes
and it happens spontaneous
yes
And if the death is instantaneous and the blows are successive to the vital part, that is brutality. So brutality is there, intention is there, knowledge is there. That we know.
So extremely brutal.
All right, not diabolic. Extreme brutality is one thing. Diabolic is another.
Successive
Whether it
blows.
is diabolic, the another word that is used in that is must be diabolic. In Jagmohan, it was reiterated by this court that if a murder is diabolically conceived and cruelly executed, so it is cruelly executed, but whether diabolically, what is that diabolic?
Diabolic, because if you also will take cumulative effect of all the three murders, because thereafter he has executed 700 meters, he has passed through 700 and 800 meters, then gave a blow to his mother-in-law Pirobati, and one blow, his head almost all has been caught.
No, that is revenge, and he has tried to establish all who are likely to have inherited the property.
I am putting
because one thing in his mind that my property has been taken away by whichever way, winning the court or any way, and he is to take a revenge.
So he has found what time will be the best so that I can execute the crime.
Correct.
In that way, he has planned. That is my humble suggestion. In what time will be best so that I can execute the crime.
But it is not dead in the night and expecting that this man has gone somewhere and will return. It is a normal time where a farmer is usually to go to the field and expected that other farmers would also be there. Maybe a coincidence that there was none. But it cannot be said at that particular time, and he was not with any plan that nobody will be there in that place. It's a coincidence that some people are. That is how the PW4 could be seen.
PW5 was seen.
PW5 was seen there.
Yes,
it is because of that reason.
Then he has traveled for 700 to 800 meters.
Correct.
Yes. Then traveled towards the village.
That continued.
Towards the village. You will automatically see the criminal degree of criminality.
Suppose the two deceased would not have been confronted him, whether there was anything, because they got confronted to the person, he hacked. Any other motive is not seen in the record. But on the way, he found that revenge is already there, intention is already there. He killed.
So he found the exact time, and he has executed the crime in such a way so that he cannot make any resistance.
What was the interaction with these two ladies prior to the killing?
The interaction is because he was the Pirobati was taking part of the he was just
ଜଣେ
hand pump ଟାକୁ
ମାରୁଥିଲା ଜଣେ collect କରୁଥିଲା ତାପରେ ଆସିକିନି ଆର ରିଆକ୍ସନ ଟା କଣ ହେଇଛି ସେଠି
both then again his son joined. Then suddenly he came and gave a blow on the cervical area. I think it is
Pirobati.
It is vertebra number 4 level.
Then comes Savitri also.
That is, you also will find it is a chop wound of 6 cm into 4 cm into 4 cm. One blow is enough.
Brutality is there.
Yes.
Brutality. ଆପଣ
Cruelty, brutality is there.
ଆପଣ ସେ ଯୋଉଟା just keep in mind ଯୋଉ decision ଆପଣ place କରୁଛନ୍ତି aggravating circumstance ର ଗୋଟେ ଯୋଉଟା ରହୁଛି murder involves exceptional ସେ ଯୋଉ କଣ planning brutality ଏଇ ଯୋଉଟା କହୁଛନ୍ତି but simultaneously ସେମାନେ କହୁଛନ୍ତି ଖାଲି aggravating circumstance ହେଇଗଲେ ହେଇଯିବ ନାହିଁ in the absence of any mitigating circumstance. Mitigating circumstance ନଥିବ କିନ୍ତୁ aggravating circumstance ରେ ଏଇ type ର ଥିବ ତାହେଲେ ଯାଇ death sentence ଦିଆହବ ଏଇଟା ତ କଥା କାରଣ ବର୍ତ୍ତମାନ ଆମେ ଦେଖିବାକୁ ପଡିବ ଏଠି let us say ଆପଣ whatever you are submitting, if we accept that it was committed with extreme brutality, right? But what are those mitigating circumstances that you are just placing in paragraph number 206 of that judgment, very judgment, Bachan Singh's judgment?
Yes. Dr. Chikale.
That 1, 2, 3. First, that offense was committed under the influence of extreme mental and emotional disturbance.
Mental or emotional mental disturbance extreme influence ଥିଲେ ମଧ୍ୟ ସେଟା ଗୋଟେ mitigating circumstance ହିସାବରେ ଧରାଯିବ, right?
Yes. The age of the accused, if the accused is young or old, he shall not be the sentenced to death. He is a person of 50 years old. at the time of commission of the crime. The probability that the accused would not commit criminal acts of violence as would constitute a continuing threat to society. The probability that the accused can be reformed and rehabilitated. The state shall by evidence prove that the accused doesn't satisfy the conditions 3 and 4 above. 5. That in the facts and circumstances of the case, the accused believed that he was morally justified.
Aji jo report ti ani produce kale, the probability of the accused can be reformed and rehabilitated. ଆପଣ ଏମିତି କିଛି ଦେଇନାହାନ୍ତି ଯେ ଇଏ ଗୋଟେ ଏଭଳିଆ ଆକ୍ୟୁଜଡ ୟାର କଣ୍ଡକ୍ଟ ବର୍ତ୍ତମାନ ଏଇ ଯୋଉ ରହିଲାଣି ପିରିୟଡ ଅଫ ଡିଟେନସନରେ ଇଏ ଏମିତି ଗୋଟେ ବର୍ତ୍ତମାନ ହେଇଯାଇଛି ଯେ ଆକୁ ସୋସାଇଟିରେ ପୁଣି ଆଉ ଥରେ ରିହାବିଲିଟେଟ କରିହବନି, ୟାର ରିଫର୍ମ ହବାର ଚାନ୍ସ ହିଁ ନାହିଁ। ଓନ୍ଲି ପନିଶମେଣ୍ଟ ଦିଆହବ ଡେଥ। ମାନେ ଆପଣ ଯାହା ରିପୋର୍ଟ ଦେଲେ, ଇଜ ଦେୟାର ଏନିଥିଙ୍ଗ ଟୁ ଶୋ ଦ୍ୟାଟ ଦିସ୍ person is beyond reform?
I am showing how he is a social. Subsequently, this judgment, Bachchan Singh judgment, has been also redefined in the subsequent judgment in Machi Singh. I'll go to that. But here, plus I am taking to lordship to one person that already I have taken. I am reading it from the report, paragraph 10. One question has been put to him. That is, when asked what he will do when he see a train track derail while arrived of train is already announced. He said he will just pass through it. Impaired came the line. Plus, even Jaha report asi, plus impaired, that impaired he has written. Plus, what answer he has given. Because he is not concerned about the other persons who are there in the train. That person should be should have told that yes, I am concerned with those persons. I should announce. I should at least tell other persons. No, I will simply pass through. I should make myself survive. Let other go. So this, I will pass. I will pass through. I will pass through it. So he is not concerned about the society. He is not concerned about the other people who are there in the train.
Yes, judgment is impaired.
Yes. He has written as impaired. Impaired in the sense, because impaired in the sense the what answer he should have given, he has not given that answer. He has, from this it is said that only he wants to save himself, because it has already been announced the train is coming. He is saying that it has been derailed.
କୋଉଟା କଣ ପଢୁଛନ୍ତି ମୁଁ
ସେ ରିପୋର୍ଟ paragraph page 10
ବିମସା ରିପୋର୍ଟ ର କୋଉଟା
second page
ଯୋଉଟା ଲାଷ୍ଟ ଫାଇଣ୍ଡିଂ ଟା ଅଛି
ଲାଷ୍ଟ
ସେଟା ଗୋଟେ page 10 ଲେଖା ଅଛି
ଏଇଟା ଟେଷ୍ଟ ଟା
yes test ଟା
କଣ ପଢିଲା ଆଉ ଟିକେ
when asked what he will do when he see a train track derail while arrival of train is already announced.
The situation is given to the person so that he will answer rationally.
He said he will just pass through. He said he will just pass through it. So that's the reason he said impaired.
He sees a train track derail while arrival of a train is already
announced.
That he will just pass through it.
ମନକ ସେ କଥା ଯେହେତୁ ବହୁତ ଲୋକ ଆସୁଛନ୍ତି ତାଙ୍କର ବଞ୍ଚେଇବାର ଥିବ ମୁଁ ଗୋଟେ ଷ୍ଟେପ ନେବି ନ କହିକି ସେ କହିଲେ ଯେ ମୁଁ ଚାଲିଯିବି.
So in that way it is impaired.
So he will not look to the interest
of the other person. Rather he is yes.
So let us say that he is a selfish man.
Yes.
He wants to save his life. So can that be a ground to?
He is also selfish. He is also selfish. He is selfish because even after getting, decree has been passed by competent court of laws in different cases, and that person has own. Suppose a report has come, there was a teasing. How can he think of eliminating two ladies and a person who is no way connected? He is only his fault is he is a illegitimate son-in-law. He was residing there. He is no way connected with the family because he has married to the Pirobati's daughter.
Teaching was by Giridhari perhaps that.
Teaching के करचंद बोली किसी नहीं कौन इस कथा नहीं खाली भाई डिसीज लिखा है specific नहीं এটা maximum we can say it is Pirobati because Pirobati is the mother-in-law of Giridhari
and land stood in
land naturally because they were fighting the litigations right from the days of her father-in-law. So ultimately Pirobati has got the decree. So at best you can say that Pirobati had teased at best, and at that very point of time Giridhari has never teased, No evidence even he has ever teased.
No, that is
Oh, that is not there. কিয়ে teach করলা খালি
Yes.
লেখা হଉଛି disease মানে disease cheat
हाँ,
course.
ଏମିତି ତ
teach course.
ଡିଗ୍ରୀ ହେଲେ ଗାଁରେ କୁହାକୁହି ହୁଅନ୍ତି.
This is the report which the provisionary officer has got
Yes.
after interaction with the members
Yes.
of the family
Yes.
of the
Yes.
ସେ ଗାଁ ଲୋକ କହୁଥିବେ ନା ଏ ଏମିତି ଦେଖେଇ ସେ ଗୀତ
ହଁ, କହୁଥିବେ.
ସବୁବେଳେ ଏଇ ହାରିଗଲୁ
ସେଟା ତ ଗାଁର ଗୋଟେ ୟୁଜୁଆଲ ଫିଚର.
ଦେଲ ଆଉ
ସିଭିଲ କେସ୍ ଡିଗ୍ରୀ ହେଲେ ଗାଁର ଗୋଟେ ୟୁଜୁଆଲ ଫିଚର ସେଟା ସେ କହିବେ. So instead of filing appropriate appeals or instead of admitting whatever has been decree has been passed by the competent court of law, how can you behave in this way to eliminate 3 members of a family? Well, that is my humble submission before Lordship.
Okay, what is other paragraph of this decision you want to place?
Yes, Lord. 206 plus then 208 and 209.
08 to 09. Okay, place for now.
According to some Indian decisions, the post-murder remorse, penitence or repentance by the murderer is not a factor which may induce the court to pass the lesser penalty. But those decisions can no longer held to be good law in view of the current penological trends and the sentencing policy outlined in section 235(2) and 323. We have already extracted the views of AW.
ଏଇଥିପାଇଁ ସେ ଯୋଉ ନୂଆ ଡିସିସନ କହିଲେ ଯେ ବର୍ତ୍ତମାନ ସେ କଣ କରୁଛି ତ ତାର ଜେଲର କଣ୍ଡକ୍ଟ କଣ ଅଛି ଇଏ କହୁଛି ସେ ତାର ସେଟା ପୋଷ୍ଟ ମର୍ଡର ଇଏ ମନ ତାର ସେଇ ଟାଇପର ସେ ରିପେଣ୍ଡ କରୁଛି ନା ନାହିଁ ଏଟାକୁ ମଧ୍ୟ ତମେ ସେଣ୍ଟେନ୍ସିଂ ଇଏରେ ନବାକୁ ପଡେ. Yes.
There are numerous other circumstances justifying the passing of the lighter sentence, as there are countervailing circumstances of aggravation. We can't obviously feed into a judicial computer all such situations, since they are astrological imponderables in an imperfect and undulating society. Nonetheless, it cannot be overemphasized that the scope and concept of mitigating factors in the area of death penalty must receive a liberal and expansive construction by the courts in accord with the sentencing policy writ at large in section 54(3). Judges should never be bloodthirsty. Hanging of murderers has never been too good for them. Facts and figures, albeit incomplete, furnished by the Union of India show that in the past, courts have inflicted the extreme penalty with extreme frequency, a fact which attests to the caution and compassion which they have always brought to hear on the exercise of their sentencing discretion in so grave a matter. It is therefore imperative to voice the concern that courts, aided by the broad illustrative guidelines indicated by us, will discharge the onerous function with ever more scrupulous care and human concern directed along the high road of legislative policy outlined in section 343, that for persons convicted of murder, life imprisonment is the rule and death sentence an exception. A real and abiding concern for the dignity of human life postulates resistance to taking a life to loss instrumentality that ought not to be done, save in the rarest of rare cases when the alternative option is unquestionably foreclosed. So, rarest of rare case theory has been evolved here in the case of Bachan Singh. You will ask me on the next decision, that is page 70. Mochi Singh and others. Paragraph page 31 to 33 and 30 to 45.
31 to 33.
3, yes.
three judge bench thila nahi constitutional bench thila na
এটা Bachan Singh টা constitutional bench judgment. Eta 3 judges bench. That page 70 will also get 3 judges bench. There are 17 murders who have taken place, and there are 3 death sentences.
Models in 5 incidents.
Yes, please. Different places. Yes, in one night. Death sentence was page 87 plus paragraph 31. Having dealt with the appeals, the running page plus I have made.
Yes.
Having dealt with the appeals on merits from the standpoint of proof of guilt and validity or otherwise of the order of conviction, we now come face to face with the problem indicated when the curtain was lifted, namely the application of the rarest of rare cases rule to the facts of individual cases in the context of the relevant guidelines. some reflections on the question of death penalty may appropriately be made before we tackle the said question in the perspective of the present group of appeals. 32. The reasons why the community as a whole doesn't endorse the humanistic approach reflected in death sentence in no case doctrine are not far to seek. In the first place, the very humanistic edifice is constructed on the foundation of reverence for life principle. When a member of the community violates this very principle by killing another member, the society may not feel itself bound by the shackles of this doctrine. Secondly, it has to be realized that every member of the community is able to live with safety without his or her own life being endangered because of the protective arm of the community and on account of the rule of law enforced by it. The very existence of the rule of law and the fear of being brought to book operates as a deterrent of those who have no scruples in killing others if it suits their ends. Every member of the community owes a debt to the community for his protection. When ingratitude is shown instead of gratitude by killing a member of the community which protects the murderer himself from being killed, or when the community feels that for the sake of self-preservation, the killer has to be killed, the community may well withdraw the protection by sanctioning the death penalty. But the community will not do so in every case. It may do so in the rarest of rare cases. When its collective conscience, this theory has come across in Murchison case, when its collective conscience is to be shocked, is so shocked that it will expect the holders of the judicial power center to inflict death penalty irrespective of their personal opinion as regards desirability or otherwise of retaining death penalty. The community may entertain such a sentiment when the crime is viewed from the platform of the motive for or the manner of commission of the crime or the antisocial or abhorrent nature of the crime, such as, for instance, manner of commission of murder, Roman I. 33. When the murder is committed in an extremely brutal, grotesque, diabolical, revolting, or dastardly manner so as to arouse intense and extreme indignation of the community. For instance, when the house of the victim is set aflame with the end in view of the roast him alive, some examples have been given. Instance, when the victim is subject to inhuman acts of torture or cruelty in order to bring about his or her death, when the body of the victim is cut in pieces on his body, then will come to 36. At the bottom.
Magnitude of the crime.
Yes, magnitude of crime. When the crime is enormous in proportion, for instance, when multiple murders, say for all or almost all the members of a family or a large number of persons of a particular caste, community or locality are committed. So my humble here the crime is enormous in proportion. And personality of victim of murder. When the victim murder is an innocent child who could not have or has not provided even an excuse, much less a provocation for murder. A helpless woman or a person rendered helpless by old age or infirmity. Here is a helpless woman. 2. When the victim is a person vis-a-vis whom the murderer is in a position of dominance.
Where it is helpless? It is not helpless.
ଯାଉଛନ୍ତି କାମ କରିବାକୁ helpless କାମ କରିବାକୁ helpless inactive.
She was armless.
Yes, that is the reason. Exactly. They were mobilized. They were not armed. They have not provoked, and from their side they have not shown any offense, any kind of offense, and they were simply taking water. And one is operating the pump, the other one is collecting the water. In that way, they are helpless women. 38 plus.
No, helpless by old age or infirmity.
No, first is a helpless woman. Then
or
a person rendered helpless by old age or infirmity.
According to you, in the past,
a person. And Pirobati is also can be said to be old. Pirobati was aged about
she could not have the capacity to resist.
Yes. In this background, The guidelines indicated in Bachchan Singh case will have to be culled out and applied to the facts of each individual case where the question of imposing of death sentence arises. The following propositions emerge from Bachchan Singh case. The extreme penalty of death need not be inflicted except in gravest cases of extreme culpability. Before opting for the death penalty, the circumstances of the offender also required to be taken into consideration along the circumstances of the crime. Life imprisonment is the rule and death sentence is an exception. In other words, death sentence must be imposed only when life imprisonment appears to be an altogether inadequate punishment having regard to the relevant circumstances of the crime, and provided and only provided the option to impose sentence of imprisonment for life cannot be conscientiously exercised having regard to the nature and circumstances of the crime and all the relevant circumstances. A balance sheet of aggravating and mitigating circumstances has to be drawn up, and in doing so, the mitigating circumstances have to be accorded full weightage, and a just balance has to be struck between the aggravating and mitigating circumstances before the option is exercised. In order to apply these guidelines inter alia, the following questions may be asked and answered. Is there something uncommon about the crime which renders sentence of imprisonment life inadequate and calls for a death sentence? Then B. Are the circumstances of the crime such that there is no alternative punishment, alternative but to impose death sentence even after according maximum weightage to the mitigating circumstances which speak in favor of the offender? If upon taking an overall global view of all the circumstances in the light of the opposite proposition and taking into account the answers to the questions posed herein above, the circumstances of the case are such that death sentence is warranted, the court would proceed to do so. In the present group of appeals, we are now concerned with the death sentence imposed on appellant Machi Singh, Kashmir Singh, Jagir Singh by the Sessions Court as confirmed by the High Court. 42. The High Court, in its extremely well considered judgment, has assigned the following reasons for imposing death penalty on appellant Machi Singh in the context of each of the 6 crimes. We can do no better than to quote the said reasons in the very words employed by the High Court in the context of each crime. Crime number 1. Machi Singh killed Biban by Jakhtar Singh, whereas Mohinder Singh killed Balwant Singh and Gurcharan Singh, which has attracted on them death penalty. Now, the circumstances of the case do reveal that it was a cold-blooded murder and the victims were helpless and undefended. Undefended, helpless. And what was their fault except that they were the immediate family of Amar Singh, like Girdhari here was. The offence committed was of an exceptionally depraved and heinous character. The manner of its execution and its design would put it at the level of extreme atrocity and cruelty. The deceased woman and her children had offered no offence to Machi Singh and Mohinder Singh. Here, Biban Bhai and Jagdar Singh. For these 2 persons, Machi Singh was sentenced to death in one appeal loss. Then crime number 2, we have found that 2 innocent helpless women named Ghamar Bhai and Raju Bhai were brutally killed in a helpless and defenseless state in their own house, and similarly a veteran couple, namely Bishan Singh and his wife Paro Bhai, were killed by Machi Singh and Jagir Singh, appellants, in similar circumstances. The crime committed carries features which could be utterly horrendous, especially when we know the weapons and the manner of their use. The victims could offer no resistance to the accused appellants. The law clamors for sterner sentence. The crime being heinous, atrocious, and cruel. Crime number 3, an old man, Vanjar Singh, and young man Satnam Singh were put to death, for which Machi Singh was sentenced to death. Okay. Several death sentences were passed against Machi Singh for committing the murder of the latter, and Mohinder Singh was sentenced to death for committing the murder of the former. These 2 defenseless and helpless men were put to death while asleep. The crime was gruesome and cold-blooded, revealing the propensity of the accused appellants to commit murder. Next crime number 4. A young man named Mohinder Singh, a breadwinner of the family, was put to death by Machi Singh while asleep in his blissful abode. The crime was premeditated, hair raising to the society at large, in the sequence of which it came to be committed, creating a great risk of serious bodily harm and death to many persons. So, in a sequence, the crime has been committed, and so many murders have taken place. Crime number 5. Saib Singh, Mukhtiar Singh, Mantubai, Pallobai, and Jita Singh were killed by 5 men.
Yes, is somewhat not really ghastly, diabolically. All these things come because in the same night, so many murders have taken place.
Yes, that is 17 murders. A series of murders going on.
ସବୁ ଶୋଇ
ଶୋଇଥିଲେ ମାରିଲା ଯାଏ।
Yes.
କେହି ନାହିଁ।
ଏଇଟା ଲେଖା ହେଇଛି in each crime after ଗଲା the ରାତିରେ ଯାଇକି
ରାତିରେ
the victims were sleeping on the cots. The lights cannot ସେଇ situation ରେ ମାରିଥିଲେ। So
they are the prime principle settled by these two judgments. Plus, then again, I will go to the other judgments. Then crime number 5, Saib Singh, Mukhtiar Singh, Mantubai, Pallo Singh, and Jita Singh were killed by 5 men, including Mach Singh and Jagir Singh, appellant. Both these appellants pursued a course of utterly cruelty and atrocity. So they pursued a course of utter cruelty and atrocity. Not only were the crimes cold-blooded, calculated, and gruesome in feature, these had been committed while spreading horror of a killing spree. In our case, the crime has been committed in the village. So there must be horror of a killing spree. They put to death a young newly married couple and rendered a young woman a widow. Then Jagir Singh, insofar as the appellant Jagir Singh is concerned, death sentence has been imposed on him by the Sessions Court and confirmed by the High Court in relation to crime number 2A, B, and V. The High Court has observed, thus, in the context of the relevant crime number 2A and B, we have found that two innocent helpless women named Hamabai and Rajubai were killed in a helpless and defenseless state in their own house. And similarly, a veteran couple, namely Vishwan Singh and his wife Parobai, were killed by Machi Singh and Jagir Singh, appellants in similar circumstances. The crime committed carries features which could be utterly horrendous, especially when we know the weapons and their manner of use. The victims could offer no resistance to the accused appellants. You will also find this common factor everywhere. The victims could offer no resistance. Offering resistance is also a factor. The law clamors for a sterner sentence, the crime being heinous, atrocious, and cruel. Then Saib Singh, Tier Singh, Mantubai, Pallobai, and Jita Singh were killed by 5 men, including Machi Singh and Jagir Singh appellants. Both these appellants pursued a course of utter cruelty and atrocity. I am skipping over to 44, paragraph 44. Kashmir Singh. Insofar as the appellant Kashmir Singh, son of Arjan Singh, is concerned, death sentence has been imposed on him by the Sessions Court and confirmed by the High Court for the following reasons. Plus, Kashmir Singh appellant caused the death of a child, Balbir Singh, aged 6 years, while asleep. A poor defenseless life put off by a depraved mind, reflecting grave propensity to commit murder. Only one child, while asleep, was killed by Kashmir Singh, and he has been put to the death sentence. We are of the opinion that insofar as these 3 appellants are concerned, the rarest of rare cases rule prescribed in Bachchan Singh case is clearly attracted and sentence of death is called for. We are unable to persuade ourselves that a sentence of imprisonment for life will be adequate in the circumstances of the crime. We therefore fully uphold the view concurrently taken by the Sessions Court and the High Court that extreme penalty of death requires to be imposed on the appellants Machi Singh, Kashmir Singh, Jagir Singh. We actually confirm the death sentence imposed on them and dismiss their appeals. Next judgment. So, you'll also get at page 94 plus. Prajit Kumar Singh versus State of Bihar. The relevant paras are 20.
Mr. Just a bit. But ଆମେ ଯଦି balance ରେ ରଖିବା ଗୋଟେ side କୁ ଆମେ ରଖୁଛୁ it's a case of triple murder.
Yes.
Right?
Yes.
And out of the 3 deceased, 2 are ladies.
Yes, please.
The other side କୁ ରଖିଲେ property dispute ଆସୁଛି,
Yes.
teasing
Yes.
ଆସୁଛି, ମାନେ constant teasing ଯାହା ଆପଣ report ଦେଇଛନ୍ତି. No criminal antecedent except 379.
Yes, please. Yes. I do admit.
Behavior prior to the occurrence was very good. Apanaka report was very good and fine with others. And after they were taken into judicial custody, nothing has been reported adverse against them. Then the psychological treatment was provided to this man who has been sentenced to death prior to the occurrence. ତେଣୁ ଆପଣ normal person ର reaction ଆଉ a person who is suffering
under
from
stress, under mental stress,
psychological problem ଥିବ case ହାରିଥିବ ତାର behavior ଏ ଯୋଉଟା ହଠାତ୍ ଏ ଯୋଉ ଇଏ ସେଗୁଡାକୁ ଗୋଟେ balance ରେ ଗୋଟେ side କୁ ରଖିବାକୁ ପଡେ ତ ଏକୁ ଦେଖିକିନି ଆମକୁ ୱେ କରିବାକୁ ପଡିବ ଯେ ଏଇଟା କୋଉଟା ଭାରି ପଡୁଛି
yes,
right? Yes. Okay, so now you proceed.
Plus Prajit Kumar Singh versus State of Bihar, page 94. Running page 94. I'll take a lordship to paragraph 26 and 27. In the case of triple murder also.
26 in the present case, yes.
Yes. 26, 27 and 28, 3 paragraphs.
Okay.
It will also get at running page 104.
26, please.
In the present case, the appellant accused was living as a family member of PW3 and PW2 and was provided with shelter and meals, although for a sum of rupees 5 and paying guest master, 5 per month, being a friend of PW1. He lived with the family not for a month or two, but for a continuous period of 4 years. There doesn't appear to be any apparent provocation. He'll also kindly just mark it, highlight it, apparent provocation. Or reason for committing the ghastly brutal murder of 3 innocent defenseless children who were aged 8, 15 and 16 years. We can safely assume that the time at which the incident happened, the children must be asleep and were not in a position to defend themselves. It has come in the evidence of PW1, PW2 and PW3 that the appellant accused had assaulted them when they were running here and there to save themselves. The medical evidence laid by the prosecution indicates the brutality in the commission of crime. Several incised wounds were caused to the deceased persons. The victims apparently didn't have any weapon with them.
This is very close to the Anadi Visay versus State of Orissa.
When PW3 plus paragraph 27, the informant and PW2, his wife, on hearing the noise, came down to find out the cause.
Yes.
Paragraph 27, plus when PW3, the informant, and PW2, his wife, on hearing the noise, came down to find out the cause for it and entered the room. They were also brutally attacked without the slightest of consideration by the appellant accused that he had lived with them for 4 years. Yeah. Not only that, when his friend on whose account he was accommodated in the house reached the place of incident on hearing the noise of his brother and sisters, he was also attacked and seriously injured. It is clear from the material placed on record by the prosecution that all these persons were unarmed and the appellant accused was the only person in the room having the deadly weapon in his hand. He could have escaped from the place, giving the threat to the persons without causing any harm to the witnesses, but he acted in different manner. The enormity of the crime is great large. The appellant accused caused multiple murders and attacked 3 witnesses. Thus, all the members of the family who were present on that day in the house became the victims of the accused. The brutality of the act is amplified by the manner in which the attacks have been made on all the inmates of the house, in which the helpless victims have been murdered, which is indicative of the fact that the act was diabolic, of the superlative degree, in conception and cruel in execution, and does not fall within any comprehension of the basic humanness, which indicates the mindset which cannot be said to be amenable to any reformation. The last 4 lines is very important. The brutality, start from the brutality of the act. I may permit to read it again. The brutality of the act is amplified by the manner in which the attacks have been made on all the inmates of the house, in which the helpless victims have been murdered, which is indicative of the fact that the act was diabolic, of the superlative degree, in conception and cruel in execution, and doesn't fall within any comprehension of the basic humanness, which indicates the mindset which cannot be said to be amenable to any reformation. In view of the aforesaid facts, we are of the view that there will be failure of justice in case death sentence not awarded in the present case.
नहीं से मिस्टर जो षडंगी जोटा कहूथिले ये तीनटा मर्डर कला परे तापरे जो माने आई विटनेस अछन से जो घरे थिले सी सेमान को भी अटैक करी पारथांदा
ସେମାନେ ଦୂରରୁ ଦେଖିଲେ ଘରେ ପଶିଗଲେ ନା ସେମାନେ ପଶିଗଲେ ଘରେ
ଘରେ ତ ଲେଡିଜ ଟା ରହିଲା ଆଉ ଛୁଆ ଦିଟା ଆଉ କଣ
ହଁ ସେମାନେ ଘରେ ପଶିଗଲେ
ଚାହିଁଥିଲେ ବି ସେମାନଙ୍କୁ ବି ମାରିଥାନ୍ତା
no that was in the village there was also a risk of being attacked by the villagers
ପୁରା ଘରୁ ଧରା ପଡଲା ନା ଏ ଲୋକଟା ଇଏ କଣ
no ଯଦି further attack କରିଥାନ୍ତା there was always a risk of being attacked by the villagers by that time he has already executed 3
ଏଗୁଡା କଣ ନିଆଉଛି ପୁରା ଟୋଟାଲ ଫ୍ୟାମିଲି କୁ ୱାଇପ ଆଉଟ୍ କରିଦେବା ପାଇଁ ଇଏ ଥିଲା
each fact has each case has its own facts circumstances
exact ଗୁଡାକ ଶୋଇଛନ୍ତି ଏଠି ଏ କେସ୍ ଯୋଉ ଆପଣ ପ୍ଲେସ୍ କରୁଛନ୍ତି innocent ପିଲା ଗୁଡା
he was staying there getting food from them staying with them as a paying guest by the mere 500 gain the trust there was no enmity attacked them killed them those persons who are also known to him came to rescue they are also attacked so the attack continued. So rightly, your lordship pointed out that part. He would have gone to the house, may not have assaulted. Dwar badi thanda, bhangi thanda, baharu ka sahani devi. It would have continued. He simply left, went to his house till police came and
police arrested him. Yes.
Plus the next judgment is Suraj Ramlas. Next page, 106 versus State of Rajasthan. Plus I will place paragraph
18.
Paragraph 18, 23 and 24. 18 you will also get at running page 114. After giving our anxious consideration to the facts, got it?
Yes.
And circumstance of the case, it appears to us that for deciding just and appropriate sentence to be awarded for an offence, the aggravating and mitigating factors and circumstances in which a crime has been committed are to be delicately balanced in a dispassionate manner. Such an act of balancing is indeed a difficult task. It has been very aptly indicated in Dennis Kunkel Kotha versus State of California that no formula of a foolproof nature is possible that would provide a reasonable criterion in determining a just and appropriate punishment in the infinite variety of circumstances that may affect the gravity of the crime of murder. In the absence of any foolproof formula which may provide any basis for reasonable criteria to correctly assess various circumstances germane to the consideration of gravity of crime of murder, the discretionary judgment in the facts of each case is the only way in which such judgment may be equitably distinguished. So each case has its own facts and circumstances. Then clause 23 on the next page. In the instant case, there is absence of any provocation. There is no material on record from which it can be reasonably held that the accused had any occasion to reasonably feel aggrieved for any unjust and improper conduct on the part of the deceased brother. It has transpired from evidence adduced that joint lands had been partitioned long back amongst the brothers, and each of the brothers, including the deceased and the accused, had been possessing his respective allotted lands. There was an occasion for difference and dispute between the accused and the deceased in respect of only 1 kilo of land, but such dispute had been sorted out at the intervention of the Sarpanch of the village about 8 to 10 months before the incident. After that, no fresh incident had taken place in recent past for which there was any occasion for the accused to feel aggrieved concerning his landed property. From the evidence, it transpired that all the 3 brothers had been residing in separate portions with a residential compound or hata. A few days before the incident, there was a quarrel between the accused and the deceased. When the accused intended to put a bar fencing on a portion of the residential complex, but the deceased objected to such course of action. Such incident cannot be reasonably held to be a cause for being temperamentally offset and for entertaining so much wrath and spirit of vengeance as may impel a man of normal composure and frame of mind to run amok and perpetrate ghastly murders of such magnitude. There is no evidence to indicate that in view of such quarrel happening a few days prior to the incident, there had been any aftermath and further dispute and resentment between the deceased and the accused either immediately before or even proximately before the incident of murders and attempts to commit murders. From the evidence adduced, it is clearly revealed that accused in a cool and calculated manner intended to wipe out the entire family of his brother. With that end in view, he selected the most opportune moment, namely the dead of night when his brother and other members of his family would remain asleep so that they would be absolutely helpless and not capable of giving any defense to save themselves. In order to ensure death, the accused chose to cut vital part of the body, namely the neck, by a sharp cutting weapon, Kasi, when his victims were asleep. He therefore succeeded in murdering his brother, Rajiram, and his two minor sons by cutting their necks without any resistance from them. He didn't even spare the poor old aunt and brutally murdered her by cutting her neck when she was asleep. In order to wipe out the whole family of his brother, the accused also attempted to murder the brother's wife and the brother's daughter when they were asleep. Both the brother's wife and the daughter were critically injured by the accused by cutting the necks. The wife of the brother, as a matter of fact, hovered between life and death and remained unconscious for a number of days, but out of sheer luck, she could survive. The daughter of the brother also luckily survived after being seriously injured when her neck was also cut by giving a number of injuries in and around neck. It has been indicated by the learned accusation judge that the accused was in full senses and had committed the murders of four close relatives, one after the other, and also attempted to commit murder of his brother's wife and daughter in a cool and calculated manner. He did not even feel remorse and being quite alive to the enormity of the crime committed by him, he escaped from the place of occurrence. It is true that the appellant was not convicted for any other offence on any previous occasion. Such fact can barely be considered as a mitigating factor in favor of the appellant that will outweigh all the aggravating factors and the circumstances in which the crime of the murders had not been committed. The murders had been committed very brutally and mercilessly of absolutely innocent persons, namely the boy and two minor sons of his brother, with whom there was no occasion to come in conflict and to entertain in gross or ill feeling. Even if it is assumed that there was still some proper dispute between the brothers, despite sorting out of such dispute at the intervention of the sarpanch for such commonplace property dispute between the brothers, particularly when the accused was no dispossessed from the position and enjoyment of his demarcated landed property by the deceased brother, it cannot be reasonably held that the accused had a genuine cause to feel aggrieved for injustice meted out to him in the hands of his deceased brother, which may impel him to cause the murder of his brother. In any event, there could not be any cause to take a decision to wipe out the entire family of the brother in a very cruel manner when being asleep they were absolutely helpless. The members of the family of his brother were absolutely innocent and two of them were even minors. Such murders and attempt to commit murders in a cool and calculated manner without provocation cannot but shock the conscience of the society, which must abhor such heinous crime committed on helpless innocent persons. Punishment must also respond to the society's cry for justice against the criminal. While considering the punishment to be given to the accused, the court should be alive not only to the right of the criminal to be awarded just and fair punishment by administering justice, tempered with such mercy as the criminal may justly deserve, but also to the rights of the victims of the crime to have the assailant appropriately punished and the society's reasonable expectation from the court for the appropriate deterrent punishment conforming to the gravity of the offense and the consistent with the public abhorrence for the heinous crime committed by the accused. This part is very important. Plus, first, in the facts and circumstances case, we are of the view that the crime committed by accused falls in the category of rarest of rare cases, for which extreme penalty of death is fully justified.
Just please come to paragraph 9. Page 270, 109, ଆପଣଙ୍କର ଯୋଉ top page number ଦେଇଛନ୍ତି 109 paragraph 9.
Yes. The prosecution case has proved by the evidences adduced in the trial is that on 7/8/1990 at about 9 p.m. the member of the family of the deceased Rajiram retired after taking their dinner. The informant Dalip Ram, with the other brother of the deceased and the wife of Dalip Ram, were sleeping in their courtyard. Rajiram and his two sons Naresh and Ramesh were sleeping in the outer room of his residential unit. Rajiram's wife Phula Devi, her daughter Sudesha, and Rajaram's father, sister Nikwai, were sleeping in their courtyard. In the courtyard of Surajram, the wife of the accused Imarti was also sleeping. After taking a meal, the appellant went out of the house. At about 12:30 a.m., Dalip Singh heard the cries of Sudesh. When he came out, he saw in the light that the accused Surajram was standing with a kasi in his hand and was assaulting Sudesh. Dalipram and the wife of the accused Imarti challenged the accused and the accused ran away. It has been proved that Sudesh had suffered severe injuries on her neck and she fell down in the courtyard. And Niku and Phula were also found lying seriously injured.
So see the timing.
Yes, Master. Absolutely.
What time the accused has
Yes,
selected.
It is in the dead of night.
Everybody was sleeping, planning, and a particular time they execute karibe, finish kar de padebe.
Yes. Yes.
So
This is
every
plan
this
and,
is a
preparation.
plan and preparation.
Yes. Yes.
Next case.
Next paragraph. Next page 118. Plus.
How many more decisions you want to place, Mr. Bhatia? We'll keep it on Thursday.
Yes.
We'll continue. Huh? 118 ने हमें फ्लैग मार दउछु सेठु आपण कंटिन्यू करी